Say yes.
Yes.
Oh,
Yes.
I forget. You all got yourselves muted, don't you? All right. Next, witnesses, raise your right hands, please. You promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of this mock trial competition.
Yes.
Yes.
Yes, Your Honor.
Yes, Your Honor.
Thank you. Gallery members, now this may seem silly since if they're doing anything, they're watching it live stream. Should we turn on the live stream so that I can swear in the gallery members? Do we want to do it that way, Mr. Bonner?
Yes, Your Honor. We are broadcasting now.
Good. All right, gallery members, anybody who's watching this from the comfort of their own home, gallery members, including teacher and attorney coaches, family members and friends, do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? I'm assuming you're all nodding your heads or saying yes. And finally, scoring panelists, please raise your right hands. Do you promise to adjudicate this mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of this mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yeah, let me get out of that screen and come back to this screen. All right. Just so everybody understands, as I said, I am not sitting in that courtroom. That's a picture my last law clerk took of my last courtroom. I am in what is laughingly referred to as my home office, which before COVID would have been referred to as the smallest spare bedroom. When I started teaching my Zoom classes at DU, my poor students had to look at the closet in this room. So my then division clerk said, why don't you put up a white sheet so that you can project onto it? And I thought, that's a great idea. So I went through the linen closet and I found an old green sheet that nobody was using. So I've got a green screen back there I didn't have to pay $350 for. I have an old sheet pinned to the wall behind me. So I thought courtroom would be a nice touch for you guys, all right? Okay, everybody take a deep breath. Once we're in competition, as far as I'm concerned, we are in that courtroom. My job is to rule on your objections and to preside over this case just as I would if we were in a real courtroom trying a real case. Everybody got that? Doesn't mean I'll be mean, doesn't mean I'll be harsh, but it certainly means I will act like a judge. We got it? Got it. All right. If there's nothing, all right. Let's call the case. Entries of appearance for the prosecution, please.
Yes, Your Honor.
Go right ahead.
Your Honor, good morning, Your Honor, members of the jury, opposing counsel. My name is Angela Wu. I'll be delivering the opening statement, conducting the direct examination of Detective Jordan Markowitz, and the cross-examination of Avery Becker.
Thank you. Other members of the prosecution team, please.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Olga Rachlenka, and today I will be conducting the direct examination of Kyle Kuzak and conducting the cross-examination of Blake Van Illen.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Sophie Gebhardt, and I will be conducting the direct examination of Alex Fuentes, conducting the cross-examination of Taylor Perkins, and delivering the closing argument. Your Honor, at this time, may we introduce our witnesses?
Yes, you may do that. Let me get the, yes, let's just go ahead and do it that way. It's easier. Go ahead. Introduce your witnesses, please.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Desta Soma, and I am Detective Jordan Markowitz.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Peyton Burnett, and I am Kyle Kuzak.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Emma Gamber, and I am Alex Fuentes.
I don't believe any of you ever saw Who Do You Trust? Go ahead. Entries of, thank you. Entries of appearance, entry of appearance for the defendant, please.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Braden Kerr, and today I will be presenting the opening statements on behalf of the defense, as well as conducting the cross-examination of Kyle Kuzak and the direct examination of Taylor Perkins.
Thank you.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Magdalena Bratic, and today I'll be conducting the cross-examination of Alex Fuentes and the direct examination of Blake Van Owen.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Charlotte Combe, and today I will be conducting the direct examination of Avery Becker, the cross-examination of Jordan Markowitz, as well as presenting closing arguments on behalf of the defense. At this time, we ask that our witnesses be able to introduce themselves.
Thank you. You can proceed with the introduction of witnesses.
Good morning, Your Honor, members of the jury. My name is Jordan Ryan, and today I am Blake Van Owen.
Good morning, Your Honor, members of the jury. My name is Ella Walters, and today I am Taylor Perkins.
Good morning, Your Honor, members of the jury. My name is Olivia Longi, and today I am Avery Becker.
Thank you. Any preliminary matters that we need to take up before we get into opening statements? Anything from the prosecution?
Yes, Your Honor, a few preliminary matters.
All right, go ahead.
Your Honor, does Your Honor and the jury have a copy of the stipulated facts?
I do. And I assume that all the scoring panelists do. If any scoring panelist does not have a copy of the stipulated facts, please turn your mic on and say so. All right, hearing none and seeing none, you can proceed, Ms. Wu.
Yes, Your Honor. Your Honor, we request that our attorneys be allowed to stand for openings and closings.
I don't assume anybody has any objection to that. I certainly don't. What else?
Your Honor, we ask that exhibits be shown by screen share as they are being authenticated by the witness and that they're constructively not admitted into evidence.
I think that's legitimate. Let me just do the one thing, make sure, and I'll just ask the monitor, is the screen share function activated for all participants?
Your Honor, I believe so, but if there's any issues going forward, I can certainly intervene and try to make that corrected.
All right, just checking. Since I'm not the host, I'm used to being able to click on that toggle, so I wanted to make sure everybody's good. Anything else, Ms. Wu?
Your Honor, we ask that exhibits be deemed published to the jury upon being admitted into evidence.
I hate the word published, but I know that's what you're taught to do. I prefer show, but that's just me. Any objection from the defendant?
No objection, Your Honor.
All right. Exhibits will be deemed admitted, published, in other words, shown to the jury upon admission. Anything else, Ms. Wu?
Your Honor, we ask that timers are able to communicate using the Zoom chat feature to avoid time discrepancies.
Anybody have any problem with that, Ms. Combe?
No, Your Honor, that's fine with us as well.
Ms. Combe, did I get your name pronounced right?
Yes, Your Honor.
Thank you. As one whose name is frequently mispronounced, I try to get them right when I can. Anything else, Ms. Wu?
Your Honor, we request that in the case someone is disconnected, they would be able to text another teammate so the situation could be communicated, but only then would text be used.
Any problem with that, Ms. Combe?
No problem with that, Your Honor.
All right, you can do that too, Ms. Wu. What else?
Your Honor, we ask for the identification of the defendant, and when the defendant is identified, we request that their camera be turned on.
Any problem with that, Ms. Combe?
That will be fine, Your Honor.
All right, we can do that too. What next, Ms. Wu?
Your Honor, we ask to reserve any remaining time on the closing argument for rebuttal.
Any problem with that, Ms. Combe? I'd do that in real life anyway.
No problem with that at all, Your Honor.
Always fun to watch people try to do a rebuttal in about 28 seconds, but sometimes you eat the bear and sometimes the bear eats you. Anything else from the prosecution, Ms. Wu?
Finally, Your Honor, we request the defense be given the same except for the rebuttal.
Any problem, Ms. Combs?
None at all, Your Honor.
Then we'll do that too. Anything else, Ms. Wu?
No, Your Honor.
Thank you. Anything the defendant wants to talk about, Ms. Combs?
Yes, Your Honor, just a few things. First, when an objection is sustained, would you like us to move to strike the testimony or consider it stricken?
You mean that if in other words, testimony's already come in, someone objects after there's an answer in the record, and then I sustain the objection? Is
Yes,
that right?
Yes, Your Honor.
I don't have any problem with that, Ms. Wu. So it's presumptively stricken if I sustain an objection to a question after the answer is in play. Yes?
Yes, Your Honor. Thank you.
Any problem with that, Ms. Wu?
No, Your Honor.
All right, we'll do that. Answers that are objected to where I sustain an objection after the answer has been given, the answer is presumptively stricken from the record. Go ahead.
If at any time the court cannot see or hear a lawyer who is speaking, a witness who is testifying, or an exhibit being displayed, we ask the court to interrupt after around 15 seconds so the problem can be resolved and so that time can be stopped. We ask this on behalf of both the prosecution and defense.
If I can't hear you or see you, I will say so because there's no point to proceeding if not. I am hoping that the batteries in my hearing aids don't run out during the trial today. If they do, I will simply start putting new batteries in and we'll proceed because I can hear you anyway, but I just can't hear you as well. Anything else, Ms. Combs?
Yes. Lastly, Your Honor, we ask in accordance with Tournament Rule 7.4 that both attorneys and witnesses, as well as trial technicians, be allowed to annotate exhibits after they have been admitted with Zoom annotation features.
Any problem with that, Ms. Wu?
No, Your Honor.
Your Honor, the defense has no further preliminary matters.
Well, I get it. Marking exhibit, I'm just telling you, marking on exhibits after they've been admitted has always been one of my bugbears. I generally didn't allow it, but it's consistent with the rules here. So if I start to talk and say, stop that, just remind me gently what we're doing. Okay, Ms. Combs?
Yes, Your Honor. Thank you.
Good for you. Work with you too, Ms. Wu?
Yes, Your Honor.
All right. Anything else, Ms. Combs?
No, Your Honor. The defense has no further preliminary matters and is ready to proceed.
All right. Deep breath, everybody. Here we go. All right. Opening statement for the prosecution, please.
Yes, Your Honor. May it please the court? Your Honor, members of the jury, my name is Angela Wu, and together with my co-counsel, Sophie Gebhardt and Olga Rokenko, represent the people of the state of Colorado. Members of the jury, this is a case about bitterness turned brutal. Brutality isn't born, it's made. The defendant's rage and recklessness turned into bitterness, and that bitterness and desire for revenge escalated to the point where she brutally murdered Mackenzie Brackman. Mackenzie Brackman was a local attorney who coached the defendant's high school mock trial team. From the outset, the defendant was disrespectful toward Mr. Brackman. During one heated exchange, the defendant stormed out of practice and vandalized Mr. Brackman's car in a fit of rage. This led to the removal of the defendant from the team. Then the defendant formed a plan of retaliation, a plan to break into Mr. Brackman's home and trash it. On March 6, 2020, the defendant broke into Mr. Brackman's home. After being alerted to the break-in, Mr. Brackman grabbed a knife to defend himself. The two struggled over that knife, and in an ultimate fit of rage, the defendant got control of it, stabbed Mr. Brackman, and killed him. As such, the state has brought the following charges against the defendant: murder in the first degree and second-degree burglary. The burden of proof lies with the prosecution, and we will prove each and every element of both crimes beyond a reasonable doubt. Through 3 witnesses, we will show who committed these crimes, what actually occurred, and why the defendant broke into Mr. Brackman's home and murdered him. First, you will hear from Detective Jordan Marquis, the lead detective on the case, who will tell you who committed these crimes. Detective Marquis will tell you that she discovered Mr. Brackman's bloody body in the doorway, located a bloody knife nearby, and found the house in disarray, a clear sign of a struggle. Detective Marquis will tell you that she saw text messages between the defendant and another mock trial team member, Alex Cifuentes, in which the defendant clearly stated her plan to vandalize Mr. Brackman's home. Detective Marquis will tell you about her analysis of cell tower data, which places the defendant near the scene of the crime at the time of the murder. Detective Markowitz will testify that in her expert opinion, it is absolutely clear the defendant committed these crimes. Next, you will hear from crime scene reconstructionist Kyle Kuzak, who will tell you what happened in Mr. Brackman's home the day he was murdered. Ms. Kuzak will tell you that in her expert opinion, this was a planned burglary gone bad. Ms. Kuzak will tell you that after being alerted to the intruder by his Ring doorbell notifications, Mr. Brackman grabbed a large knife to defend himself and engaged in a struggle with the intruder. That struggle ended with the intruder wresting the knife away from him, stabbing Mr. Brackman in the back with his own knife, and leaving him to die at his own front door. Finally, you'll hear from Alex Cifuentes, who has known the defendant for 3 years, and will tell you why the defendant committed these crimes. Ms. Cifuentes will testify to her first-hand knowledge of the defendant's bitterness and her increasingly reckless behavior toward Mr. Brackman. Ms. Cifuentes will tell you that during practice, the defendant's rage escalated. The defendant lost control and vandalized Mr. Brackman's car, which led to the removal of the defendant from the team. And that's when the defendant's desire for revenge boiled over. Ms. Cifuentes will tell you that the defendant sent her text messages, which clearly stated her plan to break in and trash Mr. Brackman's home. Members of the jury, we will show you the defendant carried out her plan and then took it even further. The defendant's bitterness and desire for revenge went beyond arguments in practice, beyond vandalizing a car. The defendant's rage and recklessness overruled reason. The defendant broke into Mr. Brackman's home, stabbed him in the back with his own knife, and left him on the floor to bleed out and die. Accordingly, the state asks you to find Avery Becker guilty of murder in the first degree and second-degree burglary. Thank you.
Thank you, Counselor. Opening statement for the defendant.
Yes, Your Honor. Can you see and hear me?
Yep. So far, so good. I can hear you. I can see you. You can proceed.
So are you ready for me to proceed?
You can proceed, Counselor.
Thank you. Too many questions, not enough evidence. On March 6, 2020, Detective Jordan Markowitz of the Denver Police Department arrived at the scene of a murder. The body laying on the ground, dead, was that of local attorney and high school mock trial coach Mackenzie Brackman. The only thing the police found was a bloody knife laying on the ground and a few videos of a masked assailant who was covered head to toe. And they struggled to find any other evidence. So, as you heard from Ms. Wu today, well, they went with an easy narrative, one of bitterness turned into brutality. Their story is that the murderer must have been a competitor on Mr. Brackman's high school mock trial team. And they found Avery Becker, a student at Colorado High School who had just been kicked off that very same team. They dug up any possible shred of evidence they could find. And now, members of the jury, my client Avery Becker is fighting for her life. But as you will see in today's case, the prosecution simply have too many questions and not enough evidence. In court here today, Ms. Becker has been charged with the crimes of burglary and murder in the first degree, which means that she knowingly entered the residence of Mackenzie Brackman with the intent to commit a crime, and in the process of committing that crime, caused the death of Mr. Brackman. Now it's going to be the job of the prosecution in today's case to prove that to you beyond a reasonable doubt. However, you will see that they will not be able to do this because there are simply too many questions and not enough evidence. Now, the defense is going to ask you to focus on 3 questions in today's case. What about the alibi? What about the motive? And what about the investigation? So first, what about the alibi? You'll hear in today's case that Avery Becker had a rock-solid alibi, but you won't have to take her word for it. Another witness, Taylor Perkins, will back up all of Miss Becker's alibi. And you'll hear the only thing the prosecution has to disprove this alibi is a set of shaky call detail records that you will hear don't prove where Avery Becker was. But that brings us to our second point. What about the motive? Now, the prosecution will claim to have text messages that show Miss Becker's intent to commit a crime. But you'll hear that even though the police had the means and ability to verify whether these screenshots were real or just hoaxes created by Miss Becker's jealous mock trial rival, Alex Cifuentes, you'll hear that the police never took the time. But third and finally, what about the investigation? You're going to hear in today's case that the police did a dangerously incomplete investigation. You'll hear that they never even bothered to locate one of their primary suspects, someone who matched the profile of the murderer and someone who was unaccounted for on the date and time of the crime. But more than that, you'll hear the prosecution's own witnesses testify that, well, they failed to find any evidence that Miss Becker was at the scene of the crime. So at the end of today's trial, my co-counsel, Charlotte Combe, will ask you these same 3 questions. And she will ask you to deliver a verdict that shows the prosecution's case simply has too many questions and not enough evidence. And we're going to ask you for a verdict of not guilty. Thank you.
Thank you. First witness for the prosecution, please.
Yes, Your Honor. The state calls Detective Jordan Markowitz to the stand.
Detective Markowitz, you've been sworn. You can proceed, counselor.
Good morning, Detective Markowitz.
Good morning.
Would you please introduce yourself to the jury?
My name is Detective Jordan Markowitz. I'm a homicide detective for the Denver Police Department.
Why are you here today?
I was the detective called to the crime scene. I investigated and analyzed the evidence surrounding the murder of Mackenzie Brackman.
How long have you been with the Denver Police Department?
I've been at DPD for roughly 13 years and worked as a detective for 7.
Do you have specialized experience in any field?
Yes, I have specialized training with cell phones, including a certification from the American Academy of Law Enforcement in cell phone technology and forensic data recovery.
And how did you earn this certification?
I took a course offered by the Academy, which included intensive training and testing.
Your Honor, per Central 702, I tender Detective Jordan Markowitz as a qualified expert in the fields of crime scene investigation, forensic data recovery, and cell phone technology.
Any objection or voir dire?
Yes, Your Honor. The defense specifically objects to tendering this witness as an expert in crime scene investigation pursuant to Rule 702. Although they have testified to their experience with the DPD, they have not laid enough foundation that this experience is in crime scene investigation.
I'd like to hear some more foundation for that. I'll sustain the objection on the basis of foundation with regard to crime scene investigation. Ms. Wu, a little more foundation would make me happy. Thank you.
Yes, Your Honor. Detective Markowitz, have you investigated homicides previously?
I have. I've been working in this field for 19 years, or it's 13 years, and I have investigated many homicides. And part of my job has been to investigate crime scenes.
Your Honor, at this time, I would like to tender Detective Jordan Markowitz as a qualified expert in crime scene investigation.
Any additional voir dire or any objection to this tender? Ms. Combs.
I maintain my objection, Your Honor.
All right. You feel the need for any response, Ms. Wu?
No, Your Honor. Detective Markowitz has laid enough foundation to her experience in crime scene investigation.
The objection is overruled. Detective Markowitz will be accepted as an expert in the fields in which she was tendered and permitted to give expert opinion in those areas. You can proceed, Ms. Wu. Next question.
Yes, Your Honor. Detective Markowitz, you say you were called to a crime scene. When did you arrive?
I arrived at 444 South Flower Street in Denver, Colorado at approximately 2:20 on Friday, March 6th, 2020.
What did you see when you first arrived?
When I first arrived at the home, I saw that it had been taped off to preserve evidence, and by a uniformed officer, I was directed towards the deceased, Mackenzie Brackman, a criminal defense attorney, and he was lying just inside of his own front door in a pool of blood, and a large knife was on the floor beside him, also covered in blood. Then just outside of the front door was a Ring doorbell camera.
Did you notice any other Ring cameras?
Yes, I observed one by the back door as I had walked around the home and was entering the residence.
So what did you see inside the residence?
As I walked in, I could tell that the home was in slight disarray, as immediately to the right was the kitchen where I observed a knife block with an empty slot, a drawer open filled with knives. Then to the left was the dining area where a chair had been tipped over and a plate was on the floor broken.
Did you notice anything else?
Yes, as I stood at the table and looked down the hall towards the front door, I saw Mr. Brackman and blood everywhere. Blood drops near Mr. Brackman and blood spatter on the wall and even up to the ceiling.
Ms. Burnett, could you please share exhibits 3 and 5 on the screen? Detective Markowitz, could you please identify exhibit 3?
Yes, this is a photo of the stab wound on Mackenzie Brackman.
Could you please identify exhibit 5?
This is a photo of the knife at the crime scene.
And are each of these fair and accurate representations of the photos as you saw them?
They are.
Your Honor, pursuant to 901, the expert has authenticated and identified exhibits 3 and 5. I now move to enter exhibit 3 into evidence.
Any objection to 3?
No objection, Your Honor.
3 is admitted and again, presumptively published to the jury. Next question, Ms. Wu.
Your Honor, I move to enter exhibit 5 into evidence.
Any objection to 5, Ms. Combs?
No objection, Your Honor.
5 is admitted and presumptively shown to the jury. Ms. Wu, you can proceed. Next question.
Detective Markowitz, what do these photos show?
These photos show that Mackenzie Brackman had indeed been stabbed, and exhibit 5 is a photo of what was later identified as the murder weapon.
Ms. Burnett, could you please stop sharing? So, Detective Markowitz, let's talk about your investigation. How did you begin?
You know, with my background in cell phones and like us putting so much information into cell phones, my first steps were to download the contents of Mr. Brackman's phone.
What did you find?
I was able to get a hold of his Ring security account passwords and data. I was able to review the videos captured on March 6th.
Ms. Burnett, could you please share exhibit 12 on the screen? Now, Detective Markowitz, while the video is playing, could you please identify exhibit 12?
Yes. This is a video of the killer entering Mr. Brackman's home through the back door.
Now, Ms. Burnett, and is this a fair and accurate representation of that video?
It is, yes.
Your Honor, pursuant to 901, the expert has authenticated and identified Exhibit 12. I now move to enter Exhibit 12 into evidence.
Any objection to 12, Ms. Combs?
No objection, Your Honor.
12 is admitted.
Yes, Your Honor. Ms. Burnett, could you please stop sharing? So, Detective Markowitz, what does the ring video mean?
In my expert opinion, between the ring video and the evidence at the crime scene, it shows that Mr. Brackman had engaged the intruder with a knife, which led to a struggle and resulted in Mr. Brackman's death. In my expert opinion, this video shows that the intruder planned to break into the home. However, they did not plan for Mr. Brackman to be there, and therefore the perpetrator in the video is the killer.
Detective Markowitz, what was the next step in identifying the killer?
On Mr. Brackman's phone, I found many emails and texts linked to an activity called mock trial. I found out he's a mock trial coach for the local high school.
So what did you do with that information?
Seeing as the number of communications on his phone, it seemed like it was a big part of his life, and I wanted to speak with the students involved in mock trial.
And did you ever speak with the students?
I did. From a student named Alex Fuentes, I learned of a text conversation between Ms. Fuentes and another student named Avery Becker.
So what did you do next?
I brought Ms. Fuentes in for an interview.
What did you learn after this interview?
I learned about a previous incident with Mr. Brackman's car, which resulted in the defendant being kicked off the mock trial team, as well as plans the defendant had made to break in.
Objection. Best evidence.
Response?
Your Honor, there's no best evidence as I am not entering in exhibit, and Detective Marquez is just testifying to what she has learned from her interview.
Ms.
And they
Combs, any response? Any response?
Detective Markowitz is talking about the contents of Exhibit 14, and pursuant to Rule 1002, that exhibit needs to be entered into evidence before they can talk about it, as it's the best evidence provided, not her testimony about it.
Well, I think that's actually an objection based on foundation, Counselor. I'll sustain it on that basis, which, by the way, judges actually get to do. Ms. Wu, let's lay some more foundation for what we're talking about here. I think it's probably doable, but I think I'd like to hear that. Thank you.
Yes, Your Honor. Detective Markowitz, did you receive anything from Ms. Fuentes?
Yes, I received screenshots from Ms. Fuentes, which corroborated what I had learned from this interview.
Now, Ms. Burnett, could you please share Exhibit 14 on the screen? Detective Markowitz, could you please identify Exhibit 14?
These are the screenshots I received.
And is this a fair and accurate representation of the screenshots?
Yes.
Your Honor, pursuant to 901, the expert has authenticated and identified Exhibit 14. I now move to enter Exhibit 14 into evidence.
Any objection to Exhibit 14, Exhibit 1-4, Ms. Combs?
Yes, Your Honor, I have two objections. First, authenticity, and second, hearsay.
Want to respond to authenticity first, Ms. Wu?
Yes, Your Honor. Detective Markowitz has already authenticated this exhibit as the screenshots of the text messages that she received from Ms. Fuentes. And if defense counsel would like to challenge the veracity of these text messages, that would go to the weight of the opinion being given, not to the admissibility of the evidence. And counsel would be able to address that on cross-examination.
Ms. Combs?
Yes, Your Honor. In accordance with Rule 901, in order to authenticate evidence, there must be sufficient evidence showing that an item is what it is claimed to be. And according to Rule 104, this must be proven through a preponderance of the evidence. If I may make an offer of proof, Avery Becker is going to testify that she has never seen these text messages, and the prosecution simply has not laid enough foundation that Avery Becker was actually the one to write these messages.
I'm going to overrule the objection. I think what you're talking about goes to the weight of the exhibit. The dispute about who typed them is, I understand. So on Authentication, I'm going to overrule the objection. Let's talk about hearsay. Ms. Wu?
Yes, Your Honor. In these text messages, the gray bubbles are text messages from the defendant, and the green text messages are.
You haven't had it. No witness has said that yet.
Oh, yes, Your Honor. Then I will lay more foundation in order to respond to that hearsay objection.
Thank you.
Detective Markowitz, who sent those gray text bubbles?
The gray text bubbles were sent by the defendant, Avery Becker.
And who sent the green text bubbles?
Those were responses to what the defendant had said, and they're sent by Alex Fuentes.
All right.
So, Your Honor,
I got that part. Now let's talk about hearsay. Why is
yes, Your Honor. So the gray bubbles are text messages from the defendant, and so they are not by definition hearsay pursuant to Rule 801 D2 as they are a statement made by a party opponent. The green text messages are not by definition hearsay pursuant to Rule 801C as they're made by Alex Fuentes, and they're not offered for the truth of the matter asserted. They are offered to show context and subsequent action taken by the defendant in order to respond to Ms. Fuentes.
Ms. Cohn?
Yes, Your Honor. The exception of 801 D2 as a statement of party opponent doesn't work for the text messages sent by Avery Becker, as the authenticity of those messages actually being sent by her are not confirmed.
Well, I've already ruled on that one, so that objection's overruled. You want to talk about the Cifuentes part of it?
Yes, Your Honor. I would just ask a limiting instruction that they not be used for the truth of the matter to the jury, but only their subsequent action of the other the gray text box.
Ms. Wu?
Yes, Your Honor. I believe the green text messages are not offered for the truth of the matter asserted.
All right. I'm going to overrule the hearsay objection. I think it's a close call on this one, but I believe that certainly in Colorado and most federal courts, close calls mean the exhibit comes in, not that it stays out. The objection's overruled. Next question, Ms. Wu.
So Detective Markowitz, what does these texts show?
In this text exchange, at the bottom, you can see the defendant says, "I'm going to wait until he's at work, then break in and trash it." That'll show him. He referring to Mr. Brackman and it referring to Brackman's home.
Ms. Burnett, could you please stop sharing? So Detective Markowitz, what did you do after this?
I immediately contacted the defendant to set up an interview.
Did you ever meet with the defendant?
I didn't. I was stopped by the attorney. However, I did obtain a warrant and collected the call detail records and cell tower data for the defendant for March 6th.
Now let's talk about these call detail records. What are call detail records?
Call detail records record call and text activity from a person's phone. So through them, I'm able to see when the communication was made and specifically through which cell tower antenna the communication went through, which is cell tower data.
What did you do with the defendant's cell tower data?
After collecting and analyzing it, I created a diagnostic diagram.
Ms. Burnett, could you please share Exhibit 16 on the screen? Detective Markowitz, could you please identify Exhibit 16?
Yes, this is a diagram including a map of the local area, including the defendant's home, Brackman's home, and the cell towers the defendant's phone was connecting to throughout a 35-minute period.
And is this a fair and accurate representation of that diagram?
It is.
Your Honor, pursuant to 901, the expert has authenticated and identified Exhibit 16. I now move to enter Exhibit 16 into evidence.
Any objection to 16, Exhibit 1-6?
Yes, Your Honor. I have 3 objections. Firstly, best evidence pursuant to Rule 1002. Secondly, misleading the jury pursuant to Rule 403. And thirdly, hearsay pursuant to Rule 801.
Let's take them one step at a time. Response to best evidence, Ms. Wu.
Yes, Your Honor. Best evidence only applies when there's a genuine question raised about the authenticity. However, there's no genuine question raised about the authenticity of this diagram as it was created by Detective Markowitz.
You want to respond to that, Ms. Cohn?
Yes, Your Honor. Rule 1002 states that an original writing or recording is required to prove the contents, regardless if it's provided in the case materials. Detective Markowitz created this diagram based off of call detail records that she obtained from the defendant's cell service provider. Those call detail records would be the actual best evidence to enter into trial today, not this diagram that's created.
All right, you want to reply to that, Ms. Wu?
Yes, Your Honor. Under Rule 1002 and 1003, duplicates are allowed unless there's a genuine question raised about the authenticity. There's not, and so this diagram does not fall under the best evidence objection.
I'm going to overrule the best evidence objection. What's your next evidence objection, Ms. Cohn?
My next objection is misleading the jury on the basis of Rule 403, if I may be heard.
Sure, I'm easy.
So on Exhibit 16, there's no demarcation of how far those red ranges from each of the cell towers go. So there's no knowledge of their distance. If I may make an offer of proof, Professor Von Owens is going to later testify the radius of these cell towers is 6 miles. And thus by having these radiuses on Exhibit 16 with no demarcation of how far wide they reach, it has the possibility of misleading the jury as to the range of these cell towers.
You want to respond to that one, Ms. Wu?
Yes, Your Honor. That is an issue at hand today, and that is subject to cross-examination for Detective Markowitz or direct examination for Blake Van Owen. However, that does not go to the admissibility of the evidence.
Ms. Cohn?
Yes, Your Honor. I would argue this does go to the admissibility of the evidence because it has a strong bias against misleading the jury. Again, there is no demarcation, and the range of these cell towers is extremely important to the testimony that Detective Markowitz is going to be giving today.
Let me make sure I understand your objection. Is your objection that there's no scale on this exhibit?
Yes, Your Honor, there's no scale, so we don't know the actual radius and range of these cell towers, which misleads the jury.
Your Honor, may I respond?
Yeah, I don't want to spend a lot of time. I don't want to get bogged down with exhibits. We don't want to kill our time doing that, but go ahead.
Yes, Your Honor, I would just like to reiterate that the range of the cell towers is subject to cross-examination.
Well, I'm going to admit the exhibit again, although I think this one's a close call. Rule 403 is an interesting objection. We'll talk about it later. Anything else, Ms. Cohn? That objection's overruled, by the way. Next question.
Yes, Your Honor, I just had the hearsay objection as well.
Okay, why is it hearsay?
Your Honor, I'm specifically objecting to that marked line on Rock Creek Parkway from Ms. Becker's home to Mr. Brackman's home as an out-of-court statement of the route Detective Markowitz believes that the defendant took the day of the murder. That can be constructively redacted, but as of now, it's an out-of-court statement being used for the truth of the matter.
Want to respond to that one, Ms. Wu?
Yes, Your Honor, that dotted line is not offered the truth of the matter asserted. It is not offered to show that the defendant indeed went along that line. It is offered to show.
Why is it there then, Ms. Wu?
Yes, Your Honor. It is offered to show that it is a possible route that the defendant might have taken. However, it is not offered to prove that the defendant indeed did take that route.
Ms. Cohn?
Your Honor, I believe that demarcated line, Detective Markowitz is going to testify that's the route she believed the defendant took the day of the murder and that it is in fact being used for the truth of the matter.
I'm going to sustain this objection and constructively take that line off the exhibit until there's more foundation for using it. I'm a little bit concerned about possibilities versus probabilities, but we haven't reached that issue yet. So that objection is sustained. The dotted line is presumptively or purportedly, or we're going to close our eyes and pretend that it's not there. It's presumptively redacted. Next question, Ms. Wu, you can proceed.
Yes, Your Honor. So, Detective Markowitz, what does this diagram indicate?
This diagram shows that at around 12:45, the defendant was near her house and at around 12:55, call detail records and cell tower data placed the defendant traveling most likely along Rock Creek Parkway. Then from 1:05 to 1:17, the defendant is placed near Mr. Brackman's residence.
Ms. Manette, could you please stop sharing? So, Detective Markowitz, who is the defendant?
Avery Becker.
Is the defendant here today?
They are, yes.
The defendant, please turn on the camera at this time.
Did we get Did we get the defendant? I don't see the defendant.
Your Honor, during this course, we would ask that the time be paused. Okay.
There she
I'm
is.
here, Your Honor. My apologies.
Not a problem. Go ahead.
Detective Markowitz, is that the defendant you have identified?
Yes, that is the defendant, Avery Becker, wearing a black blazer and white shirt.
Thank you. You may turn on your camera now.
Thank you.
Detective Markowitz, what is your expert opinion given the text messages and the defendant's cell tower data?
In my expert opinion, the defendant planned to break in and vandalize Mr. Brackman's home as revenge for being kicked off the mock trial team. Cell tower data places the defendant near Mr. Brackman's home at the time of the murder.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor, just a moment for me to get my space ready.
Certainly. You can proceed.
Good morning, Detective. I want to start off by talking about your investigation with Alex Cifuentes, all right? So you called in Ms. Cifuentes for an interview, correct?
I did, yes.
About some text messages that she showed you.
We had discussed these text messages, and then after, yes, I had brought Ms. Fuentes in.
Right. And these text messages were one of the biggest breaks in your case.
They were a part of my investigation, which went to implicate your client, yes.
So that's a yes to my question, Detective? They were one of the biggest breaks in your case?
They were a part of my investigation.
Right. And when you called Ms. Cifuentes in for an interview, she didn't bring her phone with her, did she?
She did forget her phone, yes.
You thought that was odd.
I think all of us can agree that seeing anyone without their cell phone at this time is a little odd. However, I do see that more often as I'm a police officer or a detective, and when I call people in, they normally get stressed and anxiety, and it can make them act in certain ways.
Detective, you gave me an answer that was more than what I was asking. You thought that was odd, correct?
I believe I answered your question.
So that's a yes to my question. You thought it was odd.
It did seem a little strange. However, it's totally understandable.
It might have been one of the only times you'd seen a teenager without their phone on them.
I believe we've been through this. Yes, I answered your question.
So that's a yes. It might have been one of the only times you'd seen a teenager without their phone on them.
I don't see teenagers without their phone very often, and it's understandable in this situation, yes.
So just to clarify, you did not see any of those text messages in Exhibit 14 during that initial interview with Ms. Cifuentes, correct?
I did not see them during the interview. I saw them after.
But you didn't see any of those text messages on Ms. Cifuentes' phone at all.
Ms. Cifuentes sent me a screenshot of the messages, so I did see the messages that were on her phone.
But you did not see those messages directly on Ms. Cifuentes' phone, did you?
I did not see them on the physical phone. However, I did directly see the messages that were on the phone.
Right, and you chose to simply trust the screenshots that Ms. Cifuentes sent you.
I chose to trust Ms. Cifuentes as I had interviewed her.
And you trusted the screenshots she sent you.
Yes.
Now, Detective, you have training in the Celebrite system, right?
I do.
And just to clarify, that's software used to download information off of phones?
Yes, that is true.
you've downloaded the contents of hundreds of phones before.
I have, yes. It is a big part of my job.
Right. And in today's case, you just testified on direct that you downloaded information off of Mr. Brackman's phone.
As he was not able to personally give me the evidence on his phone, yes, I did have to download those contents.
Right. And if you had obtained Ms. Cifuentes' phone, you would have been able to download the information off of it.
I would have. I did not need to, however, because Mr. Fuentes sent me those screenshots.
Detective, I wasn't asking your opinion of whether you thought you needed to or not, but if you had obtained Mr. Fuentes' phone, you would have been able to download the information off of it.
Objection, Your Honor, asked and answered.
Is there an objection, Ms. Wu?
Yes, Your Honor, I objected on asked and answered. The witness has already answered this question.
Response, Ms. Combs.
Yes, Your Honor, I've asked the question, but I have not gotten a clear yes or no. I'm just trying to clarify to the jury. If Detective Markowitz wants to explain, she has the chance to do that on redirect.
Ms. Wu?
Your Honor, Detective Markowitz has already stated her answer during the previous question, and therefore it is asked and answered.
The objection's overruled. Next question.
So, Detective, just to make this clear to the jury, if you had obtained Ms. Fuentes' phone, you would have been able to download the contents off of it.
That is what would happen if yes.
But you didn't.
I did not. Mr. Fuentes sent me the screenshots instead.
Right. Detective, I now want to talk about Avery Becker's phone. You don't know who had Miss Becker's phone the day of the murder, do you?
The phone belongs to the defendant, so the defendant.
Detective, you don't know 100% who had Miss Becker's phone the day of the murder.
Unless Miss Becker or the defendant gave the phone to someone else, the defendant would have the phone.
I'm not asking what you believe. I'm asking what you know 100%. And you do not know who had Miss Becker's phone the day of the murder, do you?
I do not know who held the phone. However, I do know that the defendant's phone belongs to the defendant.
But you don't know who had it.
I answered your question.
Detective, all of the calls from the call detail records were not responded to.
That is what the data showed, yes.
None of the texts were responded to?
As a part of that data, yes.
And they were all coming from Taylor Perkins, right?
That was the number identified as the phone in communication with the defendant, yes.
Now, you talked to Miss Becker's lawyers, correct?
Briefly.
They told you that she lost her phone on March 5th.
They told me that Miss Becker had claimed to have lost the phone on March 5th, yes.
And just to clarify, that's the day before the murder took place.
That is, yes.
They told you she was at the mall with Taylor Perkins.
They did not. They told me that the defendant, or I would not be able to meet with the defendant, and that all further communications would have to go through them.
So you don't know who Miss Becker was with the day of the murder?
As I was unable to speak with the defendant, I don't know.
Detective, you never checked the call detail records, all of the call detail records of Taylor Perkins, did you?
I collected call detail records for the defendant, which included some of the call detail records for Taylor Perkins. However, I did not collect years and years of call detail records specifically for Taylor Perkins.
I wasn't asking about years and years, but you did not collect more call detail records than were from the defendant's phone, correct?
I'm sorry, will you re-ask your question? That was, yeah.
You didn't, just to clarify, you did not collect all of the defendant's call detail records. All of, my apologies, Miss Perkins' call detail records, aside from the ones that were connected to Miss Becker's.
Yeah, similar to my previous statement, or similar to my previous answer, I said, yeah, I haven't collected the call detail records for Taylor Perkins.
Detective, you didn't download any data from Miss Perkins' phone.
I did not, as Miss Perkins is not the person in question today.
All right, Detective, I now want to talk about those call detail records you mentioned on direct. So typically, a cell phone is going to connect to a tower that gives it the best connection, right?
Yes.
And generally, this is the nearest tower.
Yes, most of the time.
But if that nearest tower is busy, a cell phone is going to connect to a cell tower that is further away.
If a cell tower is too busy, or if the nearest cell tower is too busy, it will, in the unlikely scenario, yes, that would be the case.
So sometimes cell phones don't connect to the nearest cell tower.
In the highly unlikely scenario that the nearest cell phone tower is too busy, yes, that is what would happen.
Detective, I wasn't asking about the likelihood, but sometimes cell phones do not connect to the nearest cell tower.
That is true.
All right. I want to take your attention now to Exhibit 16. If Mr. Nakayama could please screen share that. All right, Detective, I want to take your attention to that middle cell tower. An X mark is being placed on Rock Creek Parkway right now where Ms. Becker's phone may have been. Do you see that?
I do.
Now, if that middle cell tower isn't busy, Ms. Becker's phone is going to connect to it, right?
Even if the middle tower is slightly busy, the defendant's phone, if the phone is on the X, is going to connect to that nearest cell tower.
Right. But if that middle cell tower is busy, Ms. Becker's phone is going to connect to a cell tower that is further away.
If that middle cell tower is too busy, it will connect to, there's a slim possibility that it will connect to a further away tower.
So that's a yes to my question?
Yes.
So Ms. Becker's phone, if that tower is too busy, might have connected to that bottom cell tower.
Objection, Your Honor, calls for speculation.
Response?
Yes, Your Honor. This witness has been tendered as an expert in call detail records and forensic data recovery. Thus, they're able to speculate about their field and expertise, as long as it's grounded in their opinion and logic.
Ms. Wu?
Your Honor, I stand by my objection.
I must sustain the objection based on the form of the question. It called for an answer that's speculation. See if you can reformulate your question, Ms. Combs. Next question.
Yes, Your Honor. Detective, Ms. Becker's phone could have connected to that upper cell tower at the top of Exhibit 15.
As the data showed, the defendant's phone did connect to that upper cell tower at around 12:45.
But if that middle cell tower was busy, just to clarify, it might have connected to a cell tower that is further away, which may have been that upper cell tower.
If you look at the progression or the timeline of the connectivity from the defendant's phone, it connected to 3 different cell towers within a 35-minute time period, showing specifically which cell towers it connected to at a specific time.
Detective, you're getting a bit ahead of me. If that middle cell tower was busy, Becker's phone could have connected to that topmost cell tower.
I believe we've already established when and why a cell phone would connect to a further away cell tower.
Detective, I want to shift gears now and talk about the range of these cell towers. Let's look at that bottommost cell tower. Now, just to clarify, Mr. Brackman's home is by the cell tower, correct?
Yes.
It's where that green check mark is?
It is.
Now, Detective, Ms. Becker's phone could have been right there where an X mark is being placed right now and still would have connected to that bottommost cell tower, right?
Yes.
Ms. Becker's phone could have been over there where that other X mark is being placed and still would have connected to that bottommost cell tower.
Most likely.
So Ms. Becker's phone could have been at multiple locations that were not the scene of the crime and still would have connected to that bottommost cell tower.
The call detail records and the cell tower data for the defendant place the defendant near Mr. Brackman's house at the time of the murder, but what placed the defendant at Mr. Brackman's house at the time of the murder are the text messages sent by your client where she specifically states that she's going to break in and vandalize Mr. Brackman's house.
Objection, Your Honor, non-responsive. Please move the witness to answer with a simple yes or no to my question.
Well, that's two different things. Any objection, Ms. Wu, to whether the answer was non-responsive?
No, Your Honor, I believe the witness's answer was responsive.
Any response, any response to non-responsive, Ms. Combs?
Yes, Your Honor, I did not get a clear yes or no. My question was not answered.
Well, I'm going to sustain the objection as being non-responsive because it was non-responsive. But are not necessarily going to get a clear yes or no, Ms. Combs, unless you ask a question that only calls for a yes or no answer. But the answer that was given was non-responsive. The objection is sustained, and pursuant to our earlier discussion, it's automatically, presumptively stricken from the record. Next question, Ms. Combs.
So just to make this clear to the jury, Detective, Ms. Becker's phone could have been at multiple locations that were not the scene of the crime and still would have connected to that bottommost cell tower. Yes?
A simple yes or no response to this question would be misleading the jury, as taken out of context, it wouldn't be relevant to this investigation.
Detective, I'm asking yes or no. In this context, Ms. Becker's phone could have been at multiple locations that were not the scene of the crime, as we just talked about, and still would have connected to that bottommost cell tower.
Counsel, I'm saying as a simple yes or no would not be a good answer for this question, as it needs a further explanation to give context into this investigation.
Objection, Your Honor, non-responsive. My question calls for a yes or a no, and I'm not getting that.
Ms. Wu?
Your Honor, I believe the witness has already stated that a simple yes or no would not be a sufficient answer.
Ms. Combs?
Yes, Your Honor. I understand that the witness may want to explain, but you'll have the chance to do that on redirect. Right now, I'm simply asking for a yes or no. My question clearly has a yes or a no answer.
The objection is sustained. The witness will answer the question directly. Next question, Ms. Combs.
All right. Detective,
you may re-ask your question.
Thank you, Your Honor. Detective, I just want to make this clear. Ms. Becker's phone could have been at multiple locations that were not the scene of the crime and still would have connected to that bottommost cell tower, correct?
In this case, it is unlikely, however, yes.
Thank you. No further questions.
Redirect.
Your Honor, permission for Mr. Nakayama to take a screenshot of this exhibit for use in closing?
I don't see any reason why not. You can, let's wait until we see whether that arises as a problem during closing argument, Counsel. We'll wait to do that. I think you can take this exhibit down unless Ms. Wu intends to use it.
No, Your Honor.
Thank you. You can take the exhibit down, please. Next question, Ms. Wu. Redirect.
Yes, Your Honor, briefly. Detective Markowitz, why did the defendant's cell phone connect to those specific cell towers?
As we've established earlier, the reason a cell phone would connect to a further away cell tower is because the nearest cell tower is too busy. However, when you look at when these crimes were committed, the middle of the day on a Friday, a working day, and in a residential area, it's just less probable that the cell phone, there's enough traffic in the area for the cell phone to need to connect to a further away cell tower.
And finally, Detective Markowitz, assuming you were able to answer that last question, why did you place the defendant at the scene of the crime at the time of the murder?
In my expert opinion, this crime was committed by Avery Becker, as there was previous evidence where the defendant clearly stated that she was going to break in and vandalize Mr. Brackman's home.
Thank you. No further questions, Your Honor.
Thank you. Witness can step down. Next witness.
Your Honor, the state calls Kyle Kuzak as its next witness, but before I proceed, Your Honor, I would like to request a time check.
I can't do that, but your timekeeper can.
You have 13 minutes and 16 seconds left for direct.
Your Honor, may I proceed?
When you're ready, Counselor.
Ms. Kuzak, good morning. Would you introduce yourself to the jury?
Good morning. My name is Kyle Kuzak.
And why are you here today?
I am here today to give my expert opinion on the reconstruction of the crime scene based on evidence collected and offer my conclusion about what happened in the home on the day that the victim was murdered.
And what is your occupation?
I am a crime scene reconstruction investigator for the Colorado Bureau of Investigation.
What do you do as a CSR?
I specialize in analyzing and reconstructing crime scenes. So based on the evidence in a home, I can create a visual picture of what happened.
And what is your experience in this field?
Well, I've been a CSR for 19 years, so I've analyzed all kinds of crime scenes for all kinds of felonies, including homicides such as this. Over those 19 years, I've been able to continually improve and refine my process.
And what would that process be?
Well, I begin with two main principles. I walk into a case with a mindset of future reconstruction, and I assume that every case is going to trial. So I then approach a case in 5 parts.
What are those 5 parts?
First is recognition and documentation. Second is collection of evidence. Third is evaluation of evidence. Fourth is hypothesis and testing. And finally, reconstruction.
Your Honor, pursuant to Rule 702, testimony by experts, and 703, basis of an expert's opinion testimony, I am tendering Ms. Kyle Kuzak as a qualified expert witness in the analysis and reconstruction of crime scenes.
Objection of what, dear?
No objection, Your Honor.
Ms. Cusack will be accepted as an expert in the field in which she was tendered and permitted to give opinions in that field. You can proceed. Counselor?
Yes. Ms. Kuzak, did you perform a reconstruction of Mr. Brackman's death?
Yes, I did.
And how did you gather the evidence that you will discuss today?
Well, I personally visited the crime scene after it was processed, and I also looked at some evidence post-processing at the lab.
So what evidence of importance did you rely on?
I relied upon certain photos of the crime scene as well as the blood splatter present at the scene.
And would you be able to recognize these documents if shown to you?
Yes, I would.
Ms. Soma, would you please bring up Exhibit 9? Ms. Kuzak, would you please identify Exhibit 9?
Yes, Exhibit 9 is the photo of the broken plate in the victim's kitchen.
Ms. Kuzak, would you please bring up Exhibit 18? Ms. Kuzak, would you please identify Exhibit 18?
Yes, Exhibit 18 is the photo of the shoe scuff marks immediately inside the victim's back door.
Objection, speculation.
I'm sorry. What was the objection, Counselor?
The objection is speculation. The witness just referred to these as shoe scuff marks. Foundation has not been laid that this is scuff marks made by a shoe. And
all right. The objection is actually foundation then, Counselor?
Yes.
Just response, Mr. Ruthlenko.
Your Honor, may I lay permission to lay more foundation?
Certainly. The objection sustained. More foundation if you want to lay it, Counselor.
Yes, Your Honor. Ms. Kuzak, what are these scuff marks?
So these are scuff marks found immediately inside the back door of the victim's residence. Now, what we can see is that they are on the floor, so it is a logical conclusion to say that they're from shoes during some kind of scuffle.
Objection, speculation.
All of it or part of it?
I'm objecting speculation to what this witness believes is a logical conclusion, is this is not under their purview of expertise.
Response.
Yes, Your Honor. This witness has been entered as an expert in crime scene reconstruction, and thus this is within her area of expertise, as she is explaining how these scuff marks were at the scene.
Well, I'm gonna overrule the objection. You can proceed, Counselor.
Yes, Your Honor. Now, Ms. Soma, would you please bring up Exhibit 6? Ms. Kuzak, would you identify Exhibit 6?
Yes, Exhibit 6 is the photo that I personally took of the murder weapon in the crime lab.
Ms. Sema, would you bring up Exhibit 8? Ms. Kuzak, would you please bring up Exhibit 8?
Yes. Yes, Exhibit 8 is the photo of the knife block on the victim's kitchen counter, clearly missing a knife.
Ms. Kuzak, are all these fair and accurate representations of the items you identified?
They are.
Your Honor, pursuant to Rule 901, the witness has authenticated and identified Exhibits 9, 18, 6, and 8. Your Honor, I move to admit Exhibits 9, 18, 6, and 8 into evidence.
Any objection to Exhibit 9, Exhibit 18, Exhibit 6, and/or Exhibit 8?
No objection to any of these exhibits.
Exhibits 9, 18, 6, and 8 are admitted. Next question.
Yes, Your Honor. Ms. Kuzak, based on your crime scene reconstruction, how did the encounter between the victim and intruder begin?
Well, this encounter began with an intruder who was aiming to enter the victim's home. The victim had a Ring security system and paid extra to be able to keep these videos on his phone for an extended period of time.
Now, Ms. Kuzak, what observations did you make in the kitchen?
Well, there was a knife block on the counter that had a missing slot for a chef's knife and an open drawer filled with all different brands and sizes of knives.
And what did this indicate to you?
Well, it is my expert opinion that the victim, when alerted to the potential home invasion, made a frantic search through his kitchen for a knife to defend himself with, and took the knife from the block that wound up being the murder weapon.
Now, let's discuss the scuff marks and the broken plate. Where were they?
Well, immediately inside the back door of the victim's residence, there were these scuff marks on the floor, as seen in Exhibit 18. And about 5 feet further into the home, next to the kitchen table, there was a shattered plate on the floor, as seen in Exhibit 9.
And what did these indicate to you?
Well, because the scuff marks are right inside the door, my expert opinion is that almost immediately when the intruder broke into the home, the struggle began.
Now, let's discuss the progression of the struggle for the knife. How did you determine its path?
Well, I followed the blood splatter. So starting within a few feet of the kitchen table, there was a series of small blood droplets leading toward the front door.
And did this help you form an opinion?
Yes, it is my expert opinion that the intruder had wrestled the knife from the victim and stabbed him just feet to the side of the broken plate.
What was significant about the stab wound?
Well, what we know now is that the knife actually glanced off of his pulmonary artery and nicked his aorta. The knife was lodged in the victim's scapula, or more commonly known as the shoulder blade, which prevented major blood loss, but it did leave a trail of blood droplets toward the front door.
And where did the trail of blood droplets lead?
Well, as I said, it was leading toward the front door, and so that's where I went. I then saw the progression from small droplets of blood to blood cast off on the walls and even on the ceiling.
What caused the blood cast off?
Well, the knife was lodged in the victim's back and plugged this hole in the aorta. So the victim's natural instinct would have been to remove the knife, and that's what he did. So he obviously began to bleed very quickly, causing the cast off.
And how was the victim's fate finally sealed?
Well, this small hole in the aorta was unplugged when he removed the knife, and which would have sprayed blood through the entry wound and onto the walls and ceiling, and he would have died very rapidly after the knife was removed due to the major blood loss.
Ms. Kuzak, what is your expert opinion on what occurred on the day Mackenzie Brackman was murdered?
Well, my expert conclusion is that this was a planned burglary gone bad that led to the tragic and brutal murder of the victim, who through the course of a struggle was literally stabbed in the back by the intruder.
Thank you, Your Honor. No further questions at this time.
Redirect. I'm sorry. Cross-examination. I'm glad one of us is awake. Cross-examination, Counselor. My apologies.
Yes, Your Honor. May I just take a moment to prepare everything?
Sure.
Okay, I'm ready to proceed. So, Ms. Kuzak, you would agree with me when I said that, well, the police did a dangerously incomplete investigation, correct?
No, I would not.
Well, let's talk about that a little bit. Because before coming to trial today, you prepared a spreadsheet, correct?
Yes, I did.
And this spreadsheet has been marked as Exhibit 17?
Yes, there are actually 3 exhibits in this exhibit. There is my witness information tracking sheet, my evidence tracking sheet, and the flow chart I created for this case.
So Exhibit 17 was used over the course of your investigation, correct?
Yes, I continually refined it as I went along with my investigation.
And Exhibit 17 is a fair and accurate representation of the report you prepared.
Yes, it is.
Objection, Your Honor. Your Honor, the prosecution counsel has not been shown Exhibit 17. And so the witness cannot verify it without seeing it.
Do you have a copy of it, Counselor?
Oh, yes, Your Honor. If Mr.
No,
Nakayama...
I'm talking to Ms. Riklenko, who objected. I just want to make sure I understand her objection. This is in the case file, isn't it?
Yes, Your Honor, it is.
Which means you've got a copy of it already, right?
Your Honor, there is a copy within the case copy. However, while it is being identified, the witness and our counselors would appreciate if opposing counsel would screen share it in order to properly identify the exhibit.
Okay, I just want to make sure I understood what we were talking about. Go ahead and pop the exhibit up if you want to, Counselor. Mr. Kerr, go ahead.
Yes, Your Honor. If Mr. Nakayama may screen share this to the jury and the witness.
All right.
Now, Your Honor, at this time, the defense moves to admit Exhibit 17 into evidence.
Any objection to the admission of Exhibit 17?
No, Your Honor, I have no objections.
Exhibit 17 is admitted. Next question, Mr. Kerr.
So, Ms. Kuzak, let me draw your attention to line 3 in this matrix. Now, you mentioned someone here named Ailes Cifuentes, correct?
Come on, we all know that's a simple typo. It's referring to Alex Cifuentes.
Okay, so Alex Cifuentes has been identified as suspect 2, correct?
Yes, I keep track of all potential suspects as to have a full investigation.
Now, you agree that Ms. Becker was charged with the crime of murder and burglary on the 18th of March, correct?
Yes, that's correct.
But this interview right here wasn't conducted until 3 months after this crime was committed, correct?
I'm not sure that you understand. I did not conduct these interviews. That was not my job. I just organized it into this spreadsheet.
But this interview wasn't conducted until 3 months later, correct?
That is what my spreadsheet says. However, I did not control when those interviews were conducted.
Now let's move up to line 1. There's someone here named Blair Rollins, correct?
Yes.
They're identified as S3.
Yes, I identified them as suspect 3.
You identified them again in line 2?
Yes, I did.
In line 3?
Yes, I did.
And in line 4?
I find it necessary to track all relationships as to have a full perspective of what's happening.
But this person, you state right here, was unlocated, correct?
Yes, that's correct. They are, as of now, unlocated.
Now, Mr. Nakayama can take this down. So you would also agree with me that the prosecution failed to find any evidence in today's case that Ms. Becker was at the scene of the crime?
No, I would not.
So they didn't find any fingerprint evidence?
There was no fingerprint evidence as the intruder was wearing gloves.
There was no DNA evidence?
Again, there was no DNA evidence, no.
And there were no eyewitnesses that placed Ms. Becker at the scene of the crime, were there?
To the best of my knowledge, there were not, no. But that is to be expected as it was on the middle of a Friday in a residential area.
So there was no physical evidence in today's case that shows Ms. Becker was at the scene of the crime, was there?
That's not correct. However, I believe you're misunderstanding my occupation. My job is not to identify the suspect and identify who committed the murder.
Objection, Your Honor, non-responsive.
Can't tell that unless I hear the entire answer. So I'll wait till I get the entire answer first. You finish your answer, Ms. Witness.
My job is not to identify who committed the murder. My job as a crime scene reconstruction investigator is to identify how the victim was murdered.
But
Mr.
there was
Kerr?
no physical evidence discovered at the scene of the crime, was there?
Again, I was not with the first of the crime scene investigators, but to the best of my
Objection,
knowledge,
Your Honor.
no.
At this point, the witness has not given a yes or no response to my question.
Counselor, I'm going to say this again. Yes or no answers are not necessarily required unless you ask a question that only can be answered yes or no. If you believe the answer is non-responsive, that would be the appropriate objection. You haven't, but let's try not interrupting the witness until the witness finishes their answer. Go ahead and finish your answer. Then, Mr. Kerr, if you think that it's an objectionable answer, you can do so. Go ahead and finish your answer.
Because the victim and intruder were engaged for such a short duration of time, it is not likely that there would be much physical evidence present at the scene of the intruder. However, to the best of my knowledge, there was not any, no.
Thank you. No further questions.
Thank you, Mr. Kerr. Redirect.
Your Honor, there's no redirect necessary for this witness.
Thank you. The witness can constructively step down. Any additional witnesses or exhibits for the prosecution?
Your Honor, before the prosecution calls its final witness, we'd like to request a time check.
Time check, please.
You have 5 minutes and 53 seconds left for direct.
Thank you. Your Honor, the prosecution calls Alex Fuentes as its third and final witness.
Ms. Fuentes, you've been sworn. You can proceed, Ms. Gebhardt.
Good evening, Ms. Fuentes. Could you please introduce yourself to the jury?
Good morning. My name is Fuentes, and I am a senior at Colorado High School, but we all call it CHS.
Why are you here today?
I'm here because I've known Avery for 3 years from mock trial, and her anger towards our coach in the last year was just...
Objection, speculation.
It's not good. Respond to the objection as speculation.
Your Honor, this is not speculation, as it is a rationally based perception that the witness had, as Mr. Brackman was, as she will later testify to her relationship with Mr. Brackman and how she observed this.
Any other objections, Counselor? Any reply to the response?
Yes, Your Honor. Ms. Fuentes cannot testify to the emotions or feelings of Avery Becker or Mackenzie Brackman. She's not laid any foundation as to why she would think Avery Becker was angry at Mr. Brackman.
So is your objection actually foundation then, Counselor?
My objection is speculation. She should not be able to testify to the emotions of Avery Becker.
Ms. Gebb, okay. I'm going to sustain the objection on lack of foundation. I don't think that the question called for speculation, but I think additional foundation is going to be required, Ms. Gebhardt, before I'm willing to allow her to talk about what she was starting to talk about. Back to you, Ms. Gebhardt.
Yes, Your Honor. Ms. Fuentes, why are you testifying today?
I'm testifying because I saw Avery Becker and my coach interact all the time, and I saw how their interactions were incredibly scary. And I mean, look what happened now.
Thank you. I know this is hard to talk about, and we'll get back to that. For now, I'd like to talk about your mock trial team. What was how did you know the defendant?
I knew Avery from mock trial, and I knew her from school as well.
How did you know Mr. Brackman?
I knew Mr. Brackman as my coach.
What was the defendant like as a teammate?
She was really good in mock trial from what I observed. She really had a talent to make anything up on the stand and make these judges believe every single word.
Did you observe the relationship between the defendant and Mr. Brackman?
Without a doubt, all the time in practice.
What did you observe?
They argued constantly, and not just any kind of arguments, really, really big arguments, all up in his face.
Let's talk more about those arguments. Who instigated them?
From what I observed, it was Avery when coach was asking her to be to practice on time or be prepared for practice.
Is there any argument in particular that sticks out to you?
There's definitely one argument after regionals where coach was giving us all tips about how to be better at states, and Avery got up and stormed out with this red face and just looked mad.
What happened after the defendant stormed out?
She stormed all the way over to Coach Brackman's car and wrote worst attorney award on his—
Objection, Your Honor, improper character evidence.
Response.
Your Honor, this is not used to, this is pursuant to Rule 4.1, this is not used to show that the defendant acted in accordance with this trait. Rather, it is simply used to show the relationship between the defendant and Mr. Brackman, as well as a possible motive for the defendant.
Response or reply, pardon me. Go ahead.
Yes, Your Honor. If the prosecution is not using this act to show that Avery Becker acted in accordance with it to kill Mr. Brackman, then I don't see how it's relevant to today's case, as it does not show any bias or motive against Mr. Brackman, and it can be more prejudicial than probative towards the jury.
So you're also adding a Rule 403 objection then?
Yes, Your Honor. If the prosecution is not using this to show propensity, which they cannot under improper character evidence, then I don't see how it's relevant to today's case.
The objection's overruled. Next question.
Ms. Fuentes, would you like to re-ask my question?
No, I think I remember it. I was just talking about how Avery had stormed to Coach's car and wrote worst attorney award on it. And that just, how it was just so intense.
What happened after the defendant vandalized Mr. Brackman's car?
He kicked her off the team.
What happened after she was kicked off the team?
She texted me about getting her back on by talking to Coach.
What did you do?
I realized that we wouldn't be able to compete at states without her, and so I tried to convince Coach in every single way possible.
Were you successful in getting her back on the team?
No, I wasn't. He just couldn't have her back.
Ms. Burnett, would you please screen share Exhibit 14? Now, Ms. Fuentes, let's talk more about this text conversation. Could you identify this exhibit?
These are the screenshots that I took of what Avery sent me.
How did the defendant respond when she wasn't allowed back on the team?
She responded in this angry manner, saying, "I'm going to wait until he's at work and then break in and trash it," and how that would show him.
Ms. Burnett, would you please stop screen sharing? Ms. Fuentes, then what happened?
Well, after she said that, I learned that my coach's house was broken into and trashed, and it was taken a step further to my coach being murdered.
Thank you. No further questions.
Ross.
Yes, Your Honor. Just give me a moment to prepare my space, please.
Sure.
Also, may I have a time check?
You have 2 minutes and 22 seconds remaining.
Okay. Can the court see and hear me okay?
So far, so good. You can proceed, Counselor.
Mr. Fuentes, after Avery Becker was kicked off the team, you claimed that she sent you a series of text messages.
That's what you saw, yeah.
You claim that these text messages stated that she planned to go to Mr. Brackman's house.
That's exactly what she said. I asked her plans, and that's what she said.
Exactly. You claim that she said she was going to vandalize the home.
I mean, you saw it just as I did. She did.
After the murder of your coach, you got a call.
Objection, Your Honor, vague.
Any objection? I'm sorry. Response?
Your Honor, I can be more specific.
All right. I'll sustain the objection. You can ask another question, please. Go ahead.
After the murder of your coach, you got a call from a police detective, Detective Markowitz.
Yes, I did.
You told Detective Markowitz about the text messages.
That's what we talked about, yeah.
It was decided that you do an interview with him.
It's a her, I think.
My apologies, Ms. Fuentes. It was decided you do an interview with her.
Yeah, that's what I was told.
However, you forgot to bring your phone to the interview.
I wish I had remembered, but I left it on the charger at home.
Exactly. You left it on the charger at home, so Detective Markowitz didn't get to see your phone.
She said it was understandable, and so we just talked about them, and then she wanted them later.
That wasn't my question, Ms. Fuentes. I'm simply asking if Detective Markowitz didn't get to see your phone during the interview.
As I said, I had forgotten it.
But you offered to go and bring the phone back.
I tried to do whatever I could.
But Detective Markowitz said it wasn't necessary and screenshots would be fine.
She said that with my words saying exactly what was happening, as long as the text matched what I said, she said it was okay.
From the interview until you got a new phone, Detective Markowitz never got to see that old phone.
I don't think she.
I'm sorry. Was there?
I believe time is over, Your Honor.
Was there a time? Are we done with time-wise?
Yes, Your Honor, they ran out of time.
Thank you.
Your Honor, I believe I had 5 seconds remaining.
Whatever. Be my guest if you've got time.
Please answer yes or no. Detective Markowitz never got to see your old phone.
My old phone. I don't have a new phone. I don't think she saw my phone.
Thank you, Ms. Fuentes. No further questions.
Thank you. Redirect. If there's time.
Yes, Your Honor, briefly. Ms. Fuentes, why did you send screenshots of messages to Detective Markowitz?
Detective Markowitz said that after our interview, my screenshots were all she needed. And since it was exactly what my phone says, she said it was fine.
Thank you, Your Honor. No further questions.
Thank you. Any additional witnesses or exhibits for the, I'm sorry. I keep saying that because in Colorado, it's people versus. Any further objections, any further witnesses or exhibits for the prosecution?
No, Your Honor. Before the prosecution rests, we'd just like to confirm that exhibits 3, 5, 12, 14, 16 minus the dotted line, and 9, 18, 6, and 8 have all been admitted.
I believe that's what my notes show. Any objection to that confirmation from the defendant?
No objection, Your Honor.
Thank you. All right. Prosecution rests then, Ms. Gebhardt?
Yes, Your Honor, the prosecution rests.
Thank you. Let me just ask before we start with the defense case, whether anybody needs what in English mysteries is referred to as a comfort break. Anybody? All right, then we'll proceed. First witness for the defendant, please.
The defense calls Blake Van Owen to the stand.
Blake Van Owen, please. Thank you. Ms. Van Owen, you can proceed. Direct examination, please.
Good morning. Could you please introduce yourself to the jury?
Good morning. My name is Blake Van Owen.
What do you do for a living, Miss Van Owen?
I'm a private investigator as well as a professor down at CU Denver.
What education do you have?
I received a master's degree in criminal justice back in 2014.
Do you have any experience in police investigation?
I do. I started out my career over at the Aurora Police Department and then have since then spent a long time working as a private investigator and expert witness.
How many cases have you consulted on as a private investigator?
Over 100 by this point.
Have you testified in court before as an expert witness?
I have many times.
And what areas do you testify in?
I've testified in areas like crime scene reconstruction 8 times, as well as call detail record analysis 5 times, and general police investigation 12 times.
Did you do anything in preparation for today's case?
Of course, I reviewed the exhibits put together by Detective Markowitz, as well as the crime scene reconstruction from Ms. Kuzak, and I actually completed my own partial investigation for today.
Your Honor, at this time, the defense would like to tender Ms. Van Owen as an expert in crime scene reconstruction, general police procedure, and cell tower data analysis.
Any objection or voir dire?
Yes, Your Honor. Permission to conduct a brief voir dire?
We'll see. Go ahead. That is to say, we'll see if it's brief. Go ahead, Counselor.
Yeah. Now, Ms. Van Owen, isn't it true you've only been admitted as an expert in cell tower analysis 5 times?
Yes, 5 times.
And you have no specified training in cell tower analysis, correct?
I have lots of hands-on experience as well as a master's degree in criminal justice.
But you have no specified training in cell tower analysis, correct?
I didn't specify any, but again, I have a master's degree.
In criminal justice, correct?
Yes.
Your Honor, while I do not object to Professor Van Owen being entered as an expert in general police investigation tactics and crime scene reconstruction, I do object to exclude Professor Van Owen as an expert in cell tower analysis due to her lack of training and expertise.
Object. Any response?
Yes, Your Honor. Under Rule 702, for a witness to be admitted as an expert, they simply need experience, skill, knowledge, training, or education. Ms. Van Owen has testified that she has been entered as an expert in 5 separate courts, meaning that she has worked with cell data to be entered, and her testifying about cell data itself can be considered experience as she's trying to explain the concept to a jury.
The objection's overruled. I believe, Ms. Verklinko, that your questions would actually go to weight more than they would to admissibility. The objection is overruled. That's not a particular personal critique, Ms. Verklinko, just an observation. Next question.
Overall, Ms. Van Owen, what are your conclusions about the police's investigation during the case of Avery Becker?
Well, I concluded that the investigation simply left too many questions unanswered and was able to find sufficient evidence to answer them. The police's investigation involved the over-reliance on call detail records, as well as the failure to investigate key pieces of evidence in person. And lastly, a failure to investigate all possible suspects in the case at hand.
Let's take those apart one by one. First, what was wrong with the police's analysis of the cell phone records?
Well, generally, the police treated those call detail records as though they acted as a GPS. In fact, that is not even sort of what a call detail record can show. Call detail records show a range of possible locations within the area that a cell phone tower may cover, which could be up to almost 38 miles.
Are you aware of where Ms. Becker was on the day Mr. Brackman was killed?
I am. I'm aware that Avery Becker and Taylor Perkins were at the local mall in Freishack.
Your Honor, I'm going to be screen sharing what has been previously admitted as Exhibit 16.
All right.
Ms. Van Owen, what do the call detail records tell us about Avery Becker's and Taylor Perkins' location on the day Mr. Brackman was killed?
Well, if you look at those call detail records, you can see that incoming texts and calls to Ms. Becker's phone came from Ms. Perkins' phone on that day. And you can see that Ms. Perkins' phone connected to that central cell tower on Exhibit 16, and specifically antennas 2 and 3, which are the exact antennas that cover that local mall in Freisach, which is where they were.
Thank you, Ms. Van Owen. Next, you mentioned that the police failed to obtain certain pieces of physical evidence. Could you elaborate more on that?
Yes, of course. The police failed to actually get Alex Cifuentes' phone in front of them. Ms. Cifuentes claimed that Ms. Becker sent her some incriminating texts, but the police failed to actually try and authenticate that.
Why would the police need Alex Cifuentes' phone to authenticate the text messages?
Well, the police relied upon screenshots in their investigation, which in this day and age, with all the access to the internet that there is, it would be extremely easy for screenshots or pictures to be doctored or even falsified.
If the police department had Alex Cifuentes' phone in front of them, would they have been able to authenticate the text messages?
Yes, if they had bothered to get Alex Cifuentes' phone, they could have used a special technology that they have called Celebrite. And what Celebrite allows them to do is download the contents of a phone and then look through those
Objection,
phones.
Your Honor. Narrative. The witness is outside of the scope of the question.
Get response.
Your Honor, could I ask opposing counsel to clarify their objection?
Her objection was narrative.
Your Honor, my witness is testifying to the best of her ability what my question asked for. I asked why the police, or if the police could have been able to analyze the text messages, and Ms. Van Owen is answering to the best of her ability with as much detail as possible about whether or not the police could do that.
Response.
Yes, Your Honor. First of all, counsel asked if rather than a how, and additionally, the witness had begun testifying as to celebrate what it is, how it works, which is outside of the scope of the question.
Sustain the objection, but you can fix that pretty easily. Next question.
Ms. Van Owen, how would the police have been able to authenticate Ms. Cifuentes' text messages?
If they had attempted to, they could have used their technology Celebrite, which would allow them to download the contents of that phone and then look through and see if something was real or if it wasn't.
Did the police department use Celebrite on Alex Cifuentes' phone?
No, they did not.
Finally, you mentioned that there were alternate suspects that were investigated in this case. During the course of your investigation, why did you conclude that there were alternate suspects?
Well, I came across someone who had a very strong motive for committing the crime, who the police actually identified as a suspect as well.
Who did you come across?
I came across a man by the name of Blair Rollins, a former Colorado high school student.
How are Blair Rollins and Mackenzie Brackman related?
Well, Blair Rollins' father, Jonathan Rollins, had been on trial for murder. Mackenzie Brackman had been hired to defend Jonathan Rollins in court. However, Mr. Brackman lost that court case, resulting in Jonathan Rollins being sentenced to life in prison.
Objection, Your Honor. Relevance.
I need to hear the entire answer first, please. You can finish your answer, Counselor. Then you may object if you need to, Counselor. Please finish your answer.
Yes, so Jonathan Rollins had been on trial for murder. And after Mackenzie Brackman lost that case, Jonathan was sentenced to life in prison.
Thank you. Do you have an objection now that I've heard the entire answer?
Your Honor, on that basis, I do not have an objection.
Thank you. You can proceed. Next question.
Ms. Van Owen, how does that relate to Blair Rollins?
Well, Blair Rollins was actually in the courtroom when Jonathan Rollins, at the end of his trial and sentencing, yelled a threat at Mackenzie Brackman.
Would Blair Rollins have been able to hear that threat?
Yes, Blair Rollins actually participated in the trial and should have been present for that.
Did the police department investigate Blair Rollins?
No, they initially labeled Blair Rollins as a suspect, but then failed to locate Blair Rollins, failed to even try to talk to Blair Rollins, failed to do anything at all.
Overall, Ms. Van Owen, what are your conclusions about the police's conduct during the case of Avery Becker?
I concluded that the police's investigation had several errors that led to a lot of questions being unanswered. The police ran a sloppy investigation that led the case in a different direction than it should have gone.
Thank you, Ms. Van Owen. No further questions.
Cross-examination.
Yes, Your Honor. Before I begin, may I ask for a time check?
You have 19 minutes and 24 seconds left.
Thank you. Cross-examination.
Professor Van Owen, I'll begin with asking you some questions about your job. You've consulted on over 100 cases, correct?
I have.
And you've testified on behalf of the defense every single time.
The prosecution has never asked for my services, so that's correct.
And you're paid $450 per hour to testify and be here today, correct?
I am. That's a very reasonable rate.
Additionally, you're paid $225 an hour for research, writing, and investigative work, correct?
That is true.
So isn't it true that you've been paid thousands of dollars to consult on more than 100 cases exclusively against the police?
Well, I don't want to give the wrong idea. If the police had asked, I of course would have helped them. But yes, I have worked on many cases for the defense, and I do have to make a living, so I unfortunately do have to charge for my services.
Now, I'm going to ask first questions about the nature of your analysis. You were never at the crime scene, correct?
No, it was unnecessary given my job.
So until someone is charged, you don't see anything, do you?
No, I get called in to evaluate an investigation, not to run an investigation.
So you didn't see any of the information about the murder before the defendant was charged?
Again, it wasn't necessary up until that point to bring in my expertise.
However, you are testifying in this trial as to how you believe the police have dropped the ball. True?
Exactly. I have lots of experience in that line of work, and that's why I'm here today.
Now, let's discuss the knife. Isn't it true you believe it's most likely the intruder in this case brought the knife into the struggle?
I do believe that, yes.
And you further believe that the state's theory that the knife came from the kitchen knife block is wrong, correct?
Of course, yes.
Isn't it true that there is no physical evidence at all that the knife came from outside of the home?
I'm sorry, could you clarify, what do you mean by physical evidence?
Certainly. By physical evidence, I am regarding things that would have been in the crime scene photos, images, documents, DNA, etc.
Well, I mean, if you simply look at the picture of the murder weapon, it becomes very clear that that knife does not match any of the other knives found in the house and does support my conclusion.
Now, you certainly agree that there was an empty knife slot the size of the murder weapon in the knife block, correct?
I do, but the knives in that block were a very different brand than the one identified as the weapon.
And in the ring videos, the intruder clearly is not carrying a knife in his hands, correct?
Just because someone's not carrying a knife in their hands certainly doesn't mean they don't have one, but no, they're not holding it in those videos.
Additionally, isn't it correct that there was an open knife drawer in the kitchen?
It is true.
And there were a multitude of knife sizes and brands in this knife drawer, true?
There were several types of knives, but again, none of those matched with the one identified as the murder weapon.
Now, let's discuss the recording of Jonathan Rollins. You heard the recording from the hearing of Jonathan Rollins, correct?
I did. It was chilling.
And Jonathan Rollins is the one who speaks in Exhibit 22, true?
That's true.
Now, the recording that you mentioned earlier has a direct threat against Brackman, correct?
Yes, a threat of revenge.
So the threat Jonathan gave was, I'll get you back if it's the last thing I do, correct?
That's true.
And you've previously stated that Jonathan Rollins said Brackman was going to die, true?
That's correct.
So in your words, getting someone back and murder are the same thing?
Well, ma'am, I think if you'd heard the recording, you'd agree with me. The chilling nature in which Jonathan Rollins swore revenge, if nothing else in his life was to be accomplished, chilling. That's all I can really say, ma'am.
Now, I'm going to re-ask that question because you've tried to take it further. In your words, getting someone back and murder are the same thing, yes or no?
That's not correct, ma'am. That's not what I've said.
Now, let's talk further about the alternate suspect you mentioned. Isn't it true that you claim a more reasonable suspect would be Blair Rollins?
I do. My main point on that effect, though, was the lack of investigation into Blair Rollins, to be clear.
And just by looking at a yearbook photo, you came to the conclusion that Becker and Rollins are of the same build, correct?
I did.
Did you do an analysis of all other classmates of Avery Becker with respect to size and build?
I did an analysis of people I thought had motives for committing the crimes.
Now, isn't it true that that you have no evidence that Blair Rollins in any way threatened Mr. Brackman at any time?
That Blair Rollins specifically threatened Mr. Brackman? No, but again, the lack of investigation is what we really have to remember in this circumstance.
And returning to that recording that we mentioned earlier, that recording is something that you based your conclusions off of, correct?
It is one of the things that assisted me, yes.
And within that recording, you gathered the conclusion that Jonathan planned to kill Brackman, true?
I gathered that Jonathan Rollins wanted revenge and that the police should have investigated.
Now let's talk about the investigation. You claim that Detective Markowitz should have looked into additional suspects, correct?
Absolutely.
And you conducted an extensive search in an attempt to locate Rollins, true?
I did. Blair Rollins fled the state. Yet another reason he should have been investigated.
And you accused Detective Markowitz of not gathering enough cell tower evidence, correct?
That's true.
You believe that she should have gathered Miss Perkins' data, correct?
Absolutely.
However, you didn't gather that evidence yourself, did you?
Ma'am, that wasn't my job, so I had no need to. It was the police's job to gather the evidence today.
Now, you also accused Detective Markowitz of making assumptions about the status of Mr. Brackman's ring notifications, correct?
I did.
However, you didn't check the status of his notifications yourself, yes or no?
It was unnecessary, so no.
Now, you did conduct in your own extensive investigation an attempt to show Miss Rollins' location and actions on March 6, 2020, true?
Sort of, ma'am. I conducted a partial investigation surrounding Blair Rollins to highlight the inadequacies in the police's investigation.
However, this last question is yes or no. You did not collect additional evidence to demonstrate Miss Becker's location or actions on March 6, 2020, correct?
That was never my job, so no.
Thank you. No further questions, Your Honor.
Redirect.
Yes, Your Honor. Ms. Van Owen, was it your job to run an investigation to find who killed Mr. Brackman?
Absolutely not. My job is to look at the investigation done by the police and evaluate if it was a good investigation or not. Unfortunately, that's not what we've seen today.
Was it your job to prove that Blair Rollins killed Mr. Brackman?
Absolutely not.
Did you have any burden in this case to prove anything?
I did not.
Thank you, Ms. Van Owen. No further questions.
Thank you. You can step down, Ms. Van Owen. Thank you. Next witness.
Your Honor, the defense calls Taylor Perkins to the stand.
Thank you. Ms. Perkins.
Now, Ms. Perkins, could you please introduce yourself to the jury?
Well, of course. Hi, my name is Taylor Perkins.
And what do you do for a living, Ms. Perkins?
Well, I'm currently a freshman at CU. I'm a theater major.
So where did you go to school last year?
Well, last year I was a senior at CHS, Colorado High School.
So do you know the defendant in today's case, Avery Becker?
I do, yeah. She's my best friend.
Do you know the victim in today's case, Mackenzie Brackman?
Yeah, he was my mock trial coach.
Now, Ms. Perkins, do you know whether Avery Becker murdered Mackenzie Brackman?
Objection, Your Honor, lack of foundation.
Response.
Your Honor, this question is being used to lay foundation.
Response, Your Honor.
Sure.
Your Honor, the witness has not testified to how she could know whether the defendant killed Mr. Brackman.
May I respond, Your Honor?
Reply.
Your Honor, the question was not, did Mr. Brackman kill, or did Avery Becker kill Mr. Brackman? The question was, do you know if Miss Becker killed Mr. Brackman? And that is to lay foundation.
Well, I'm going to overrule the objection, but the witness only has to answer that foundational question, yes, I know, or no, I don't. After that, we'll see what happens. So you can answer the question, Ms. Witness. The objection's overruled, but you need to answer it, yes, I know, or no, I don't.
So, Ms. Perkins, do you know?
Absolutely. I was with Avery the whole day.
So, did Avery Becker kill Mackenzie Brackman?
Absolutely not. No.
Now let's back up a bit and talk a little bit about your relationship with Avery. What was it like?
Really good, honestly. We're best friends and we did lots of activities together.
What activities did you do?
Well, my favorite was probably musical theater. And then there was mock trial, which was probably Avery's favorite. Keys Club, school, obviously, and we just hung out all the time.
So what is this mock trial activity?
Well, it's really similar to musical theater, except usually there's not dancing or singing, except there was that one time. But typically there's not singing, and we even get to wear costumes. Except our costumes are suits. But it's really similar.
Now, when you were in mock trial, were you able to observe the relationship between Avery and Mr. Brackman?
I was, yeah.
And what was this relationship like?
Tense is probably the best way to put it.
What do you mean?
Well, Avery could be a little bit unprepared at times, but she was still by far the best on the team. But Avery could be a little bit unprepared. And I think that was something that irked Coach a little bit.
So did Avery and Coach Brackman ever fight?
They could, yeah.
So what happened?
I think it was, about a month before regionals. Avery came in really unprepared. Probably the most unprepared I'd ever seen her. Don't get me wrong, she still performed flawlessly. But Coach got a little bit upset.
Objection, Your Honor, speculation.
Bonds.
Your Honor, this witness has already testified to being aware of the relationship between Avery Becker and Mr. Brackman.
Response, Your Honor.
Sure.
Your Honor, the witness cannot testify to the personal feelings and state of mind of the victim.
The objection is sustained. The witness can testify to what the witness actually observed, but other than that, I think the question called for speculation. The objection sustained. Next question.
So, Ms. Perkins, what did you observe between Coach Brackman and Avery?
Well, like I was saying, I think it was about a month before regionals. Avery came in really unprepared, and she still did amazing. Don't get me wrong. But I thought Coach got a little bit heated, and he demoted her to B team.
So what did you decide to do?
Quite frankly, I didn't love mock trial. And I had just been cast as Adelaide in musical theater, the play Guys and Dolls, which is the lead. So I had that on my plate. And I didn't want to be on mock trial if I didn't have friends. So I quit in support of my friend, of Avery.
So do you know about Avery and Mr. Brackman's relationship after you left?
I do, yeah.
Were they ever able to get along?
Objection, Your Honor. Lack foundation.
Response.
Your Honor, the foundation for this question has been laid.
Response, Your Honor.
Yes.
The witness, Your Honor, the witness has not testified to how she knows what happened following her removal from the team, as she was not on the team anymore and therefore would not have observed it.
So your objection is actually foundation, correct?
Yes, lack foundation, Your Honor.
Response to that, Mr. Kerr.
Yes, Your Honor. The previous question was, do you know about the relationship between Mr. Brackman and Avery after you left? The witness answered yes, and that is enough foundation to ask this question.
I disagree with you, Mr. Kerr. The objection sustained. If you want to lay more foundation, you may. Next question.
So, Ms. Perkins, how did you know about the relationship between Avery and Mr. Brackman?
Well, Avery told me.
Objection, Your Honor, hearsay.
She hasn't. That objection is premature because she hasn't asked what was said. All right. The objection's overruled, but let's see what the next question is, shall we?
So, Ms. Perkins, what did Ms. Becker tell you about the interaction?
Well, she told me it was a little tense. And
Objection, Your Honor, hearsay.
Now, Mr. Kerr, you want to respond to that?
Yes, Your Honor. This is something. So this is not hearsay, as this is an excited utterance.
Ms. Gebhardt?
Your Honor, this is not an excited utterance, as the defendant would have told, Ms. Perkins at a later time, and therefore would still be an out-of-court statement made by.
Well, I'm going to sustain the objection again as lack of foundation. It might be an excited utterance, but not based on what I've heard so far. I'm going to sustain the objection based on lack of foundation. Mr. Kerr, you can proceed.
So, Ms. Perkins, do you know what happened to Avery after you left the mock trial team?
yeah, ultimately she was kicked off.
Now, were you aware of Avery's mindset after this point?
Yeah, I was.
And what did you observe about her reactions?
Well, we talked about it a lot, and then I saw that she was really, really upset. I mean, she loved mock trial the way that I love musical theater, and I think she wanted to do anything she could to get back on.
So what did she do?
Well, we talked about ways she could get back on, and she tried apologizing to Coach multiple times, and I think she even tried to get a summer job to help pay back Coach Brackman for his car.
Now, let's move forward a bit to the date of the murder, the date of March 6th. Now, where were you this day?
Well, Avery usually picks me up and drops me off from school. And I was texting her and she wasn't responding.
Did you figure out why she wasn't responding?
Yeah, when she picked me up, I asked her, I talked to her about it, and we realized that she'd lost her phone.
So what did you two decide to do?
Well, we didn't have all that much going on in school. Tech week for musical theater was the next week. And we'd taken our lit quiz earlier in the week, so we didn't really have much going on. So I suggested we just spend the day looking for it. So we did.
So where did you go?
Well, we completely retraced our steps from the night before. So we went to the mall, the Fry Shack, just looking for her phone.
And did you ever find it?
No, it was the weirdest thing. I thought we might have, just because she has a really distinct ringtone. It's Defying Gravity from Wicked. It's kind of an inside joke. But no, we never found her phone.
So were you with Miss Becker between, say, noon and 2 on the date of the murder?
Yeah, I was.
Did she ever leave your side at this point?
No, not at all.
So was she with you the entire day?
She was, yes.
So did Avery ever go to Mr. Brackman's house?
Absolutely not, no.
So did Avery kill Mackenzie Brackman?
Absolutely.
Objection, Your Honor, asked and answered.
Response.
Your Honor, my first question was, did Avery Becker murder Mackenzie Brackman? And this question is, did Avery Becker kill Mackenzie Brackman? They're two different questions.
Ms. Gebhardt.
Your Honor, earlier on in the witness's statement, the question asked was, did she kill Mr. Brackman? And to which the witness already answered.
Mr. Kerr.
The definition of murder and kill are different, and it changes the question enough that I can ask this question again.
The objection sustained. Next question, Mr. Kerr.
So, Ms. Perkins, Now, Ms. Perkins, did Avery ever have the opportunity to go and kill Mr. Brackman?
Absolutely not. I mean, like I said, she was with me the whole day.
And Ms. Perkins, well, is Miss Becker guilty?
Absolutely not. No.
Thank you. No further questions.
Cross-examination.
Your Honor, before I like to begin, I would like to request a brief time check.
Time check, please.
You have 11 minutes and 50 seconds left.
Ms. Perkins, I would like to begin by asking you a few questions about your mock trial team. Isn't it true that you thought Mr. Brackman was a mediocre coach?
I did, yeah. I thought he could make some poor decisions for our team.
Miss Becker drove Mr. Brackman crazy, correct?
Yeah, I think he could. I don't think he liked that she was a little bit unprepared sometimes.
Isn't it true that there are few did bother Miss Becker?
From what I saw, yeah, but I didn't entertain it.
It bothered Miss Becker enough to play some pranks on Mr. Brackman, yes?
Some pranks, but she absolutely didn't kill him.
Onto the subject of one of those pranks. Isn't it true that you heard about the practice in which the defendant vandalized Mr. Brackman's car from Miss Becker?
Objection, hearsay. Or this question calls for hearsay.
I really need to hear the answer before I can hear an objection. Can I hear the rest of the answer, please? Then you may object if you choose, Counselor. Can I hear the entire answer, please? Thank you.
Of course. So I did hear from Avery. She told me about the practice.
Your Honor, at this point, I object to hearsay.
Well, again, as I said before, I believe the objection is premature. The objection is overruled. We'll wait and hear what the next question is, however. Ms. Gebhardt.
Isn't it true that Miss Becker wrote on Mr. Brackman's car?
Yeah, she told me that she thought it was dry erase marker, though I think she felt awful about it.
And she wrote this in permanent marker, though, ruining the paint in the car, yes?
Apparently. I wasn't there, but apparently.
Isn't it true that Miss Becker was then kicked off the team?
Yes, it was.
After she was kicked off the team, you discussed ways she could get back on, yes?
Yes, I mean, she's my best friend and she loved mock trial.
She then texted every team member asking to get back on, yes?
I believe so, yes.
And Alex Cifuentes is a member of this team, correct?
Yes.
Now, back to the subject of Miss Becker. You and Miss Becker were best friends, correct?
Absolutely.
You even quit something you're pretty good at in support of Miss Becker, yes?
Of course, in support, but not because of Avery.
Isn't it true that you and Miss Becker realized that she was missing her phone on the morning of March 6th?
Yes, that's true. And we spent the whole day looking for it.
You first went to the mall, correct?
Yeah. Sorry.
And then you went to the Fry Shack, correct?
Yeah, I was calling it and texting it, and I hoped we'd find it. She has a pretty distinct ringtone, like I said.
Miss Becker's phone is like her third kidney, never out of reach, correct?
I'd assume it's like most teenagers' third kidneys, but yeah, Avery left her phone.
And yet she didn't notice its absence until the following day?
I suppose not, no. Well, that's when we discussed it anyway.
Now, Miss Perkins, following this incident and when you learned that Mr. Brackman was in fact murdered, you talked to the defendant, yes?
I did. I mean, we were both completely shocked. I mean, who would kill Coach Brackman?
And she suggested to you that Blair Rollins committed this crime?
That's what she'd heard, yeah. I mean, it made total sense. He was kind of a weird guy.
Thank you, Miss Perkins. No further questions.
Redirect.
No redirect, Your Honor.
Thank you. You can step down. Next witness for the defendant, please.
The defense calls Avery Becker to the stand.
Ms. Becker, you've been sworn. First question.
Good morning, Miss Becker. Please introduce yourself.
Good morning. My name is Avery Becker.
Now, Miss Becker, you're here today because you've been charged with murdering Mackenzie Brackman. Did you kill Mr. Brackman?
No, I did not.
We'll talk more about him in a moment. But for now, Ms. Becker, what does your life look like now?
Well, currently, because of this trial and everything, it's not super great, but I really can't wait for my future plans of going to college. And I'm super hopeful that I can continue my mock trial journey, maybe even become a coach. That's my goal.
Now, Ms. Perkins just explained what mock trial is. Did you enjoy the activity?
Oh, absolutely. It was something that came naturally to me. I was just really good at it. So it was probably my favorite extracurricular activity.
Who was your coach?
Mr. Mackenzie Brackman was my coach for all 4 years of high school.
And what was your relationship like with Mr. Brackman?
You know, I will honestly admit it was not the greatest. We disagreed on a lot of things involving mock trial, and that caused tension.
All right, Ms. Becker, I now want to talk about the day of the murder, March 6th of 2020. Where were you?
Well, I wasn't at school that day. I had actually decided to skip school with Taylor, my best friend, so we could go to the mall. We were looking for something there.
What were you looking for?
My phone. It had gone missing the night before. I had it, and then I went home, I went to bed, and when I woke up the next morning, I could not find it anywhere.
Ms. Becker, were you ever able to find your phone?
You know, Taylor and I looked all over, and Taylor called it several times, but we never found it.
All right, and I want to talk about mock trial. You mentioned you enjoyed the activity a lot. Were you successful in Mr. Brackman's program?
I'd say I was pretty successful.
Objection,
I
Your Honor.
mean,
I'm sorry, what was the objection?
Your Honor, I objected on relevance.
Response?
Yes, Your Honor. This goes directly to Avery Becker's relationship with Mr. Brackman and thus her lack of motive in today's case.
Ms. Wu?
Your Honor, whether or not Ms. Becker was successful in Mr. Brackman's mock trial program does not make any fact more or less probable in this case.
The objection's overruled. Witness can answer.
Ms. Becker, were you successful in Mr. Brackman's mock trial program?
I'd say I was pretty successful. By the time I was a senior, I had made it onto our A team, which is the top team. And I even won a couple of awards at our regional competition.
What awards did you win?
I won Best Closing Argument and Best Attorney. I was really proud.
And how did Mr. Brackman react once he won those awards?
We were actually at practice a couple days after the competition when he and I started to argue about the awards. He said some really cruel things.
What did he say?
While we were arguing, he told me that I didn't deserve my awards.
Objection.
He told me that I had only won them because of my good looks.
Was there an objection? My apologies.
I'm sorry, was there an objection?
Yes, Your Honor. I will wait until the witness is finished answering.
Thank you. Go ahead and finish your answer.
Well, Mr. Brackman had told me during the argument that I had only won the awards because of my good looks and charm, which I thought was something that was so mean for him as a coach to be saying to me, his student. It really hurt me.
Objection, Your
And
Honor.
because of that, I did something that I will regret for the rest of my life.
Objection, Your Honor. Hearsay.
You want to respond, Ms. Cohn?
Yes, Your Honor, we're using the statements of Mr. Brackman not for the truth of the matter that Avery Becker relied on her good looks and talent, but for the effect on the listener.
Ms. Wu?
Your Honor, I stand by my objection.
Objection's overruled. The witness can answer.
So you mentioned that after Mr. Brackman said those things, you did something. What did you do?
After we had finished arguing, I stormed out because I didn't want to be at practice anymore. And after I stormed out, I went and wrote on Mr. Brackman's car in what I thought was dry erase marker. I thought it would just come off. I only found out later that the marker was permanent and it wouldn't come off as easily.
Did Mr. Brackman find out?
He did. He had actually followed me out into the parking lot and saw what I had done and made the decision then and there to kick me off the mock trial team, which I understand now.
Now, Ms. Becker, did you try to apologize to Mr. Brackman?
Of course I did. I felt horrible. I knew that no matter what he had said, I should have never, ever reacted like that. So I went the very next day in person to apologize. But he didn't want to see me. His secretary would not let me in.
Were you able to apologize to him?
I did end up sending him a text. I figured that that would be the next best thing since I couldn't do it face to face. So I texted him my apology. And I even told him that I would get a summer job just to help pay to repaint his car.
Ms. Becker, why did you want to apologize to Mr. Brackman so much?
I knew my actions were horrible and wrong, and I should have never done that, no matter how angry I was from our argument. My reaction should not have been to write on his car.
Let's talk about some other people involved in today's case. Did you hear Alex Cifuentes testify earlier today?
Yes, I did.
Now, Ms. Cifuentes claims you sent her a text asking for help to get back on the mock trial team after you were kicked off. Did you write that?
No, absolutely not. If I was going to get back on the team, I wanted to make things right with Mr. Brackman first.
Now, Ms. Cifuentes also claims you sent her a text saying you were going to break into Mr. Brackman's home. Did you write that?
No, I don't even know where Mr. Brackman lives.
Did you see the Ring videos brought up earlier in today's trial?
I did, yes.
Ms. Becker, are you the person in the Ring video?
I am not. I understand that that person and I have a similar-ish height and build, but a lot of people have that body type and can look like that.
Ms. Becker, were you at Mr. Brackman's home the day of the murder?
No, I was at the mall all day with Taylor.
Did you want to hurt Mr. Brackman?
Absolutely not. In his final days, I was still doing everything I could to apologize for the car incident.
Thank you. No further questions at this time.
Ross.
Yes, Your Honor. Now, Ms. Becker, I want to start by asking you some questions about your cell phone. You claim to have last seen it on March 5th at the Fry Shack, correct?
Well, that's what I remember, yeah.
And afterwards, you went to the mall with Miss Perkins, correct?
Yes, I did.
And you walked all around the mall, yes?
Yeah, we did.
And so the entire time while you were at the mall, you didn't notice your phone was missing, correct?
Well, the last time I remember having it was at the Fry Shack, but maybe I lost it in the mall. It was lost. I don't really remember exactly where. Otherwise, I would have found it by now.
Right. So the entire time while you were at the mall, you didn't know your phone was missing, correct?
I didn't know.
And then afterwards, you went home, yes?
I did, yes.
And isn't it true you're not allowed to use your phone until you get your homework done?
That's correct. That's my mom's rule.
Right. So that means your parents take your phone.
Not necessarily. I mean, they trust me to follow the rule, so I always do.
Right. So you went home that evening, and neither you nor your parents noticed that phone was missing, correct?
It wasn't really my top priority. I had a lot of homework and tests to study for, and my parents were pretty busy with work too.
Right. So you didn't realize your phone was missing until the next morning, yes?
Yeah, that's correct.
And you realized around 9 o'clock?
When I went to pick up Taylor, yes.
Right. So it was well over 14 hours from when you left the Fry Shack until you realized your phone was missing.
I guess it was that long, yeah.
Now I'm going to ask you some questions about your relationship with the deceased, Mr. Brackman. Mr. Brackman was your mock trial coach, correct?
Yeah, he was.
And you and Mr. Brackman didn't get along.
Our relationship was not great.
In fact, you two would argue almost every single practice, correct?
That's correct. We did not agree a lot.
Right, and at the mock trial practice after regionals, you were angry at Mr. Brackman.
He said some really hurtful things. I mean, I thought it was really weird for him to be saying those types of things to his student, me.
Right, so you were angry at Mr. Brackman, correct?
Sure, I was a little frustrated.
And you stormed out of practice.
I did.
And you saw Mr. Brackman's obnoxious white car in the parking lot, correct?
I did see his car, yes.
And so you wrote Worst Attorney Award with a permanent marker, correct?
I totally thought that the marker was dry erase and that it would just wipe off super easy and there was no harm done. And when I found out that it was permanent, I felt horrible.
Right, so you wrote Worst Attorney Award with a permanent marker, correct?
I will regret it forever, but yes, I did do that.
Right. And so afterwards, Mr. Brackman even came out and started to apologize to you.
He did, but once he saw what I had done, he wasn't so forgiving.
Right, and after you wrote Worst Attorney Award, you stood there thinking how what you had done would show Mr. Brackman what you really thought of him, yes or no?
I was in the heat of a moment, yes.
And after Mr. Brackman saw what you had done to his car, he removed you from the team.
Permanently.
Right, and that made you even madder, correct?
I was still pretty angry, yeah.
Right, and so after you were removed from the team, you were even madder, correct?
I was frustrated, yes.
Ms. Becker, my question is whether or not you were even angrier, even madder, correct?
I was angry, I was frustrated, I was mad, I was all of those emotions. I would agree with that, yes.
Right. And so then you went home and you told your mother that Mr. Brackman kicked you off the team for no good reason, correct?
I was ashamed of what I had done and I didn't want my mom to know about it. So yes, that's what I told her.
Right, and you didn't tell your mother that you had vandalized Mr. Brackman's car with a permanent marker, did you?
I was ashamed of my actions.
Right, and you didn't tell your mother that you had vandalized Mr. Brackman's car, correct?
That's correct. I did not tell her.
And you lied to your mother, correct?
I wouldn't say I lied, but I definitely didn't tell her everything that had happened. I was ashamed. I didn't want her to know about it.
Thank you. I heard my answer. And so afterwards, you told your mother that you would get back at Mr. Brackman if it was the last thing you did.
I did not mean it. And saying that certainly does not mean I was going to go and murder him. That's ridiculous.
Right, Ms. Becker, you say you didn't mean it, but did these words just magically come out of your mouth?
I will admit I did say that, but I absolutely did not mean it or was ever going to follow through on that threat.
Right, Ms. Becker, you said that you would get back at Mr. Brackman if it was the last thing you did. Yes or no?
I did not mean it, but I did say that, yes.
Thank you. No further questions, Your Honor.
Redirect.
Yes, Your Honor. Now, Ms. Becker, why didn't you initially tell your mom that you had vandalized Mr. Brackman's Porsche?
Like I said, I was really ashamed of my actions, and I didn't want my mom to know what I had done.
And why did you tell your mom you would get back at Mr. Brackman?
I was angry in that moment. I was frustrated with the argument I had had with Mr. Brackman. I was frustrated that I had been kicked off the team. So I said that, but I would never, ever meant it.
And Ms. Becker, did you want to get revenge?
Objection, Your Honor. Outside the scope of cross-examination, I believe counsel has already asked a question that would pertain to getting revenge or getting back at Mr. Brackman.
I may respond?
Sure.
Yes, Your Honor, I asked at the end of my direct if Ms. Becker would ever want to hurt Mr. Brackman. Now I'm specifically asking her if she would ever want revenge. The prospect of Ms. Becker wanting revenge was key to Ms. Wu's cross-examination and thus is inside the scope of the cross.
Response.
Your Honor, nowhere in my cross-examination do I ever bring up getting revenge. I did ask about getting back at Mr. Brackman. However, counsel has already asked a question pertaining to it.
The objection is overruled. Witness can answer the question.
So, Ms. Becker, did you want revenge?
Absolutely not. In Mr. Brackman's final days, I was still trying to get back on the mock trial team and apologize for the incident with his car.
Thank you. No further questions.
All right, thank you. The witness can step down. Next witness for the defendant.
Yes, Your Honor, the defense rests and is ready to proceed with closing arguments.
Defendant rests. Is the prosecution ready to proceed, or would either the prosecution or the defendant like a few minutes to get themselves organized? I'm easy either way.
Your Honor, the prosecution is ready to proceed.
All right. Defendant ready to proceed, or does the defendant want a few minutes?
The defense is ready to proceed, Your Honor.
Your
All
Honor,
right.
I would just like to request that all remaining time be reserved for rebuttal. Again.
We'll see how much time you've got left when you're done, Ms. Gebhardt. You can proceed. Closing argument for the prosecution.
May it please the court? Your Honor, members of the jury, at the beginning of this trial, we told you that this is a case about bitterness turned brutal. We have a bitter young woman who committed a brutal crime. Now, in her opening statement, my co-counsel told you the state would meet its burden by proving beyond a reasonable doubt each and every element of both crimes with which the defendant is charged. The issue in this case is whether the defendant's bitterness, recklessness, and desire for revenge led her to break into Mackenzie Brackman's home, ending with the murder of her coach. The evidence has shown the defendant did just that. Members of the jury, brutality isn't born, it's made. For the defendant's recklessness and rage turned her bitter, and then that turned brutal. Members of the jury, the testimony you heard from the prosecution today answered 3 crucial questions surrounding this tragedy. Who committed these crimes? What actually happened? And why the defendant broke into Mr. Brackman's home and murdered him. First, we showed you who committed these crimes. Detective Markowitz told you about text messages from the defendant in which she described her plan to break into Mr. Brackman's home and trash it. Detective Markowitz also told you that she was able to conclude that it was absolutely clear the defendant went to Mr. Brackman's home on March 6, 2020 with the intent of breaking in and vandalizing the home and ended up fatally stabbing Mr. Brackman. The defendant committed these crimes. What happened? Detective Markowitz testified to describing the crime scene in disarray, a clear sign of a struggle. Detective Markowitz also testified to seeing the body lying in a pool of blood with blood splatter up the wall into the ceiling, along with the murder weapon also covered in blood. In addition, Kyle Cusack explained what happened. She concluded that this was a planned burglary gone bad. Ms. Cusack told you the steps of what happened. 1, the defendant broke as the defendant was notified to the presence of an intruder by his Ring doorbell notifications. 2, as the intruder broke in, the defendant Mr. Brackman then frantically searched for a weapon, grabbing a knife from his own kitchen. 3, the intruder and Mr. Brackman then fought over that same knife. And finally, the intruder was able to take the knife from Mr. Brackman and stab him above his left shoulder, leaving him to die at his own front door. Finally, why the defendant committed these crimes. Alex Fuentes helped you understand the defendant's increasingly reckless behavior towards Mr. Brackman over the course of the mock trial season. Ms. Fuentes testified about numerous heated arguments between the defendant and Mr. Brackman, and how one such argument even escalated to the point where the defendant's rage took over. The defendant vandalized Mr. Brackman's car, writing Worst Attorney Award on it. Why did the defendant kill Mr. Brackman? Because her desire for revenge did not stop there. She made a plan to break in and trash Mr. Brackman's home, but her rage took over, and the defendant took it from a vengeful break-in to a brutal murder. The defendant even stated that she would get back at Mr. Brackman if it was the last thing she did. The exact phrase Professor Blake Van Owen associated with threat of murder. The last thing Avery Becker did was murder Mr. Brackman. Members of the jury, the defendant wasn't born a murderer, but a bitter relationship with Mr. Brackman and a burglary gone bad made her one. Your duty as jurors is to evaluate the facts and evidence, and the facts and the evidence show the defendant committed this crime. As such, the prosecution asks you to find the defendant guilty. Thank you.
Closing argument for the defendant, please.
Yes, Your Honor. Too many questions, not enough evidence. Ms. Gebhardt just got up here and told you that today you heard a story of bitterness gone brutal. But I want to take your attention to those 3 questions we asked you at the beginning of today's trial. What about the alibi? What about the investigation? And what about the motive? Now, at the end of today's trial, it's clear that none of these 3 questions have been answered because the prosecution simply did not have enough evidence to answer them. Let's take a close look at each of these questions one by one. What about the alibi? The prosecution just told you that they proved who committed the crime, but you just heard from Avery Becker and her best friend Taylor Perkins that Miss Becker was nowhere near Mr. Brackman's home the day of the murder. Now, the prosecution tried to use call detail records or CDRs to prove that Avery Becker's phone was at Mr. Brackman's residence. However, as you heard from Detective Barkowitz herself today, Miss Becker's phone could have been at multiple locations that were not the scene of the crime and still would have connected to that bottommost cell tower. Those CDRs can't tell us exactly where Miss Becker's phone was the day of the murder. And even if the CDRs did tell us what we wanted them to, it wouldn't matter. Avery Becker lost her phone on March 5th, a day before the murder ever even took place. And on March 6th, she was at the mall all day looking for her lost phone. Professor Von Owens looked into Taylor Perkins' call detail record and found that connections with her cell phone were made at a cell tower that covered the mall and fry shack, consistent with her alibi. Detective Markowitz did not bother to check Taylor Perkins' call detail record, did not bother to check the alibi of her primary suspect. 2. What about the motive? The prosecution told you that they proved why Avery Becker committed the crimes she's been charged with today. They used Exhibit 14, those self-incriminating text messages. But members of the jury, Detective Markowitz didn't use the Celebrate system she had training in to download those text messages off of Ms. Fuentes' phone. Instead, she trusted screenshots of those messages. Screenshots that could have easily been doctored, messages that Ms. Becker denies ever even writing. What's more, you just heard Ms. Becker tell you that in the days leading up to Mr. Brackman's murder, she was asking for his forgiveness. She wanted to apologize, not get revenge. And lastly, what about the investigation? The prosecution just got up here and told you that Avery Becker was at the scene of the crime, and they told you it was a burglary gone wrong. But remember back to Detective Kuzak. Remember how Detective Kuzak couldn't tell you that Avery Becker's fingerprints or DNA was found in the murder weapon. Miss Becker's DNA and fingerprints weren't even found at the scene of the crime. The prosecution didn't seriously look into any other alternate suspects. And the only piece of evidence they have that remotely connects Avery Becker to this case are those call detail records, which we already show leave a lot of room for reasonable doubt. So we have an alibi, no motive, in a case with a lot of missing links. What does this mean for you, members of the jury, and the decision you should be making at the end of today's trial? The prosecution carries the burden of proof. They had to prove to you that on March 6th of 2020, Avery Becker unlawfully trespassed Mr. Brackman's home and caused his death while unlawfully on his property. They had to prove both of those things to you beyond a reasonable doubt. Members of the jury, beyond a reasonable doubt is the highest burden in our criminal justice system. So if you thought it was odd that Detective Markowitz did not check the alibi of her primary suspect, that is a reasonable doubt. If you wondered why Detective Markowitz chose to trust a piece of evidence that could have easily been tampered with, that's reasonable doubt. And if you wondered why the prosecution could not find a single piece of evidence that actually connected Avery Becker to the scene of the crime, members of the jury, that is reasonable doubt. The prosecution simply had too many questions and not enough evidence to answer them. Because of that, you must find Avery Becker not guilty. Thank you.
Rebuttal?
Your Honor, before I...
Yeah, time check. I'm gonna save you the time from even asking for a time check, Ms. Gebhardt.
Thank you, Your Honor.
How much time has Ms. Gebhardt got left?
You have 44 seconds.
Okay, and go ahead, Ms. Gebhardt.
The defense offered too many coincidences. A professional second guesser who never investigates crime scenes but only criticizes those who do, and a missing phone the day before a murder. They offered too many coincidences and not enough credibility. The best friend as the alibi. Remember, members of the jury, this is a case about bitterness turned brutal. Find the defendant guilty.
Thank you. All right. All done. Thank you. All right. All the participants, turn your cameras back on, please. Okay. All you participants, as soon as we get everybody's cameras on, thank you. All right, participants, give yourselves a hand. You're all done for this morning. Yay, give yourselves a done. And now all of you take a hugely deep breath, please. Whew, right? Okay, I'm going to let the scoring panelists do their thing. I have some comments that I'd like to make to the group, but I want to wait until all the scoring panelists have told us that they've turned in their scores so that anything I have to say won't be perceived as trying to influence the scoring panelists. So we'll just wait for that. I'm going to take a short recess for my own Okay. All right. Let's see. How we doing? Do we have all of our scoring panelists back yet?
Your Honor, we've also received all the score sheets, so they're all received now.
Okay. Now you have to listen to me. First of all, I had asked you all to applaud yourselves. Let me applaud all of you. One of the reasons that I love doing this is that trial advocacy has been a serious and meaningful part of my life since I was a kid. It sounds dumb, but I decided to become a trial lawyer because I thought, and this is not a gag, I thought Perry Mason was the coolest thing I had ever seen in my entire life. I can remember sitting on the couch with my father in 1957. I was 9 years old when Perry Mason came on, and turning to my dad and saying, I want to do that. And I never wanted to be a fireman, and I never wanted to be a cowboy, and I never wanted to be an astronaut. I wanted to be a trial lawyer. It's the only thing I ever wanted to do in my whole life. And I was lucky enough that I got to spend my professional life doing that. So for me to get to watch you and watch you get excited about this means the world to me. Because I'm going to say something that's going to sound maudlin, but it's true. When you're going to be trial lawyers after I'm dead, but it means something to me to see people like you care, because what trial lawyers do is incredibly important, because what trial lawyers do every day is affect the lives of real people in real circumstances. Trial lawyers are advocates. Advocate, the Latin meaning to be called to speak for. Damn. How cool is that? To be called to speak for. To speak for people who can't otherwise speak for themselves. All right. Now let's talk about some things that I saw, and I'm not going to, I'm going to try not to say anything that goes to anybody too specifically. This is going to be more general things. In other words, things that I saw more than one person do, unless I think it's screamingly significant. One thing that I think all of that would help everybody, and this is one of my pet peeves with lawyers in my real courtroom, and it's something I teach my students at the law school, which is making sure that you always call an exhibit by its name. None of us wants to be called, hey, you, right? Neither do exhibits. We have names, exhibits have names, and exhibits names are exhibits 1, exhibit 2, exhibit 6, exhibit 18, as opposed to saying, I'm showing you exhibit whatever. What is this a picture of? Tell us what exhibit 16 shows us, so that you refer to the exhibit every time you mention it by its actual exhibit number, because it makes your record clearer and it makes your advocacy better. That's particularly important for those of you when you were putting in groups of exhibits at the same time. All right. This is exhibit 6. This is exhibit 18. Whatever it is, make sure that the fact finder knows what the exhibit number is. There were occasionally times when the contents of an exhibit was shown to the jury before the exhibit was actually admitted. And I'm thinking here of the Ring video. In a real courtroom, I would not have allowed the video to be played until the video was admitted, because what's the inside the video is the contents of the exhibit. We don't talk about the contents of the exhibit until the exhibit itself is admitted. Okay. Let's see. I always find it interesting in these competitions when someone says, in my expert opinion, and that came up a lot. Real experts don't testify like that, but I understand that that's what happens in this kind of a competition. Let's see. In general, you displayed a pretty good handle on the rules of evidence. With one thing, you may have noticed that I kept probing about whether an objection was actually based on foundation. And I think you might want to think about that before you fall back to things like speculation, because a fair number of what you were asked, questions you were asking, were actually foundational questions, were actually objections to foundation. And I did what real judges will do in courtrooms, which is, at least in Colorado, judges have the ability to sustain an objection for a basis that wasn't stated if there's a legitimate objection. That's why I kept going. I'll sustain the objection on foundation, and then I encouraged you to lay more foundation, and we got around the issue. But be careful about what your actual objection is. I would also suggest, with regard to objections, pardon me, I got a frog in my throat this morning. Not COVID though, I've had both my vaccinations. One of the few advantages of being as old as I am, listen for questions that are argumentative. Listen, and especially listen to questions that are leading on direct. There was a fair amount of that I think you can fix by simply making sure that you ask who, what, where, why, when, how questions, as opposed to did you, would you, could you questions. Because a lot of judges will sustain objections to leading to did you, would you, could you questions if there are too many of them. All right. You can ask a question or two like that if it's foundational. Don't, and I said this several times, try to avoid arm wrestling with witnesses about whether they gave you a yes or no response. And I understand that part of this has to do with the way these competitions are structured. You get a lot of non-responsive answers in this kind of a competition. You have to decide whether you want to fight about that every time or just move on. But arguing with the witness about whether your answer called for a yes or no question, that happens a lot on TV. I've never thought it was particularly effective to say to a witness, I want you to answer this question yes or no, because all a witness has to say when you say that is, I'll do that. If you ask me a question, I can answer yes or no. And that's a legitimate response. Let's see. One thing that a lot of you did, and this is something I teach my students too, try to get away from using the word relationship when you're talking about how two people get along with each other. And I would suggest in this problem that the word relationship is fraught with potential unfortunate connotations. When you say the word relationship to civilians, what do you think they're talking about? That's a rhetorical question. Don't answer me. You know what I'm saying. But when you say, tell us about Coach Brackman's relationship with Avery Becker, if you said that in a real courtroom, you would be potentially suggesting something that you have no intention of suggesting. What you really are asking is, tell us how Coach Brackman and Avery Becker got along, right? That's what you're really asking them. You fall back on the word relationship because lawyers fall back on it, but I would suggest that you get away from using it and use something that's more colloquial. Let's see. Remember, when you're talking about experts, when I offer you the opportunity to object or voir dire, in real life, voir dire of an expert only goes to their qualifications. It does not go to things that would otherwise be weight. I did not do it here because this is a learning experience. In my real courtroom, when lawyers asked questions on voir dire that went to weight, I would interrupt them and say, that question goes to weight. That question goes to weight. That question goes to weight. If what you really are going to do is cross-examine, just save it and pound them upside the head and shoulders when you're cross-examining them without taking time to ask voir dire, unless the voir dire actually goes to their qualifications to give an opinion. Let's see. Several of you commented on answers after answers came in, and it's almost always unconscious. you'd get an answer and then you'd say right or thank you or yes. It's reinforcement of an answer like that is technically improper. Why? Because to me, those kinds of reinforcements of answers are commentary on the answer, right? And in the law, we have a word for commentary on the evidence. What's it called? Anybody? Come on. What do you call commentary on the evidence in the law? It's called argument. Okay? That's what commentary on the evidence is. It's argument. And you get to argue at the end of your case, not in the middle of it. So try to avoid reinforcing answers. Let's see. And by the way, some of what you're doing is stuff I'm teaching my students at the law school as we speak. All right. So don't think that just because they've already completed college and taken evidence that they're doing any better than you are. One thing for all of you, slow down. All right. And part of this is because you know you're on a clock and you know they're running a stopwatch. You have this tendency to just go too fast. And when you go too fast, you give up the opportunity to pause, to emphasize words that you'd like to emphasize, and to have anything other than the same vocal tone coming out of your mouth all the time, which is what I just did, right? Several of you did a good job of remembering to pause between words, and went slowly. That's good. If you need to remember anything to why pauses can become important, remember that commercial for real, comfortable jeans. All right. Where if you think about it, there's a period after each word. And it's good for emphasis and it's good to remember. I'll shut up. Any questions you guys want to ask me? That was fun. Thank you for letting me do this. Even if I did have to get up at an early on a day when I usually get to sleep, I'm glad that I got to spend this time with you. Any questions that any of you have? Oh, come on. I don't bite. Maybe what you guys want to do is just have me shut up so you can go get something to eat, right? Nod your heads. Say yes. It's okay. All right. The last thing I'm going to do for each of you, I am going to give you my email address. If any of you has questions that you would like to ask me that I didn't discuss here, or to ask me whether I might have any specific things for you yourself, I'll be happy to contribute those if you want. I would rather wait, though, to anything that you ask about your own specific performance. I think in fairness, I would prefer not to have to answer those questions until this competition is completely finished. Fair enough? I don't think it would be fair for me to give what amount to coaching help to individual folks in advance of the final rounds. All right. So here's my email address. All small letters, McGahey, McGahey, at Jams Denver, JamsDenver.com. After I retired in November, I joined JAMS, which is a mediation and arbitration service here in Denver, and that's what I'm now doing. I didn't get to retire and do nothing. As my wife pointed out, somebody has to pay the mortgage. So it's me. So I'm continuing to do that. And I owe my wife that. Anyone who would put up with me for more than 50 years deserves all the props that she can get. But now, just for the last thing for fun, somebody asked me how I met my wife. Go ahead, somebody. Anybody?
Your Honor, how did you meet your wife?
I sat down in second grade and turned around. Now, we didn't like each other very much, but that's a true story. We actually have a second grade class picture somewhere in the house that our children think is the funniest thing they've ever seen in their lives. And I recognize that I am probably old enough to be your grandparent, but it's okay. I am impressed with each and every one of you. Keep up the good work. I hope that, I don't know how the scores are going to turn out because I never ask and I never score, but I hope that you get to go, some of you get to go forward. And if you don't, well, then we'll be back next year, won't we? Anything else? Okay. Anything from scoring panelists that you'd like to comment on these folks at all? Nope. Anything, Mr. Courtroom Monitor, that we need to do to wind things up? Or are we done?
No, Your Honor, you can dismiss at your leisure.
Wow, I actually get to do that again. One of the things about being a judge, I have to tell people now, is that I'm not a real judge anymore, which means I can't order anybody to do anything. But let me know if I can help you. Good luck in the future. I'm going to leave the meeting. Thank you, scoring panelists. Thank you, Courtroom Monitor, and thank you for parents, grandparents, coaches who are watching, but mostly thank you, each and every one of you participants, for providing me with such a pleasant way to spend my Saturday. Thanks, everybody.
Thank you, Your Honor, and thank you all for your
Thank
time.
you. Thank you.
Thank you.
Thank you.